So now, no more.
Are you aware of this order? Please.
It is state appealment. Yes.
Let us take instruction. Lordship allow.
That's been dismissed when? Dismissed on
1/4. 1 month. Exactly 1 month.
So, 1st April. What is the decision?
Direction was to restore our position and to grant the benefit of our salary from 19th August 2014. Our order of regularization was cancelled. That was under challenge. That was set aside.
Regularization was done, that was withdrawn.
Withdrawn. That was the subject matter of challenge.
So,
It has been restored back by the order of the SAHOO.
yes, I have to give him all the benefits. Das, now you cannot shirk your responsibility.
That is obviously in terms of the order passed by the Honorable Apex Court, my lord. We can
It's not an apex court has not
No.
simply dismissed the
simply
matter.
dismiss the matter.
So this order remains.
Yes. So back, grant us a fortnight time.
Huh? No. The order. Ah, 22nd is the last day. Okay.
Pardon to mention, my lord. Pardon to mention, my lord.
All
These
these special petitions have been discussed.
Yes,
All-
yes. One order.
Yes. One order.
Yes.
There is a leave of granted by the assembly.
My lords, mention was made. Mention was made.
So the legal ground, what is the so urgent matter that it cannot be
That's-
even for a day?
My lords, that they have already opened the financial bid on 28th supplement.
So that when you come tomorrow, they are already open. This.
Item number 3.
What is the urgency that?
Milords,
Wait.
Milords, what has happened, Milords? They have cancelled the tender, Milords, and they have on the same day, Milords, an antedated, Milords, I may be pardoned, Milords, due to my ill health, Milords. Milords, they have cancelled the tender on an antedated, Milords. On 20th of 4th, the notice was on 18th, and on the same day, they have floated a retender, Milords, and the retender, Milords, is supposed to be, Milords, the last date is on Monday, Milords. Well, much job bless, Milords.
Item number 3. Sorry, item number 4.
Already the tender was cancelled. Already the tender was cancelled on 23rd of April, and on this technical bid has been 23rd of April 2026. On the same day, it has been re-tendered on a technical ground that you have mentioned Mr. So
He tell me the date for submission is well,
the last date is 8th May.
so it's not so urgent to come tomorrow.
Item number 5.
Let's say, on behalf of senior advocate, Lalat Samtra, one pass over my lord.
Why you not be?
Mr. Senior Advocate Lalat Samtra, he will appear this matter. Senior Advocate Mr. Lalat Samtra, he will appear in this matter. One pass over I am asking for. Yes, my lord. Okay, let's say, because today the work order is going to be issued. Because today the work order is going to be issued, my lord. As,
Item number 6.
Milords, item 6 and 3 are similar.
Yes, come tomorrow.
Milords, item 6. Milords, item 3 and 6 are similar, Milords. It can be kept tomorrow, Milords. Much obliged, Milords.
Item number 7.
Quickly, I'll just issue. But she could see, I'm agree by annexure 1, 2, and 3.
Because of the urgency, I know. Otherwise, I will not there tomorrow. Urgency is that in that matter they will issue the work order. That's what.
Which on the other side?
No, it's not notice it to go municipality belongs.
So we give a notice then
Earlier policy put is there.
issue a notice is that man.
Item 5.
Come on Monday then.
Let's very
You issue a notice.
Plus, it's hall me or suna beta, so it may not take.
Fine. Post, give a copy to them. But they can't sanction. Anybody is appearing.
Suna they don't have a council standing here. So only no after notice they engage somebody. That is the problem. But it's, they one entry they can appear. Yeah. Because the municipality had issued the tender notes, not the state. Normally, not once issues notice, notice goes to them. We don't give them the advance notice that we file the application.
Milord,
What is the urgency that it cannot be?
Milord, it cannot wait, Milord. The reason being, I'm telling. The reason being, it's a case of extension of existing license. for the purpose, they have brought in a new policy with effect from 1st of April 2026. Your Lordships are aware about that. Now, in the new policy, for the first time, that's right, my Lord. I am on the question of extension. That Doloi's case, Prabhas Chandra Dolo. They have, Lord, 1st of April 2026 brought in the new policy. In the new policy, for the first time, they are introducing MGER, monthly guaranteed excise revenue. But is another thing that such a concept is not there in the act, not there in the rule. That's another thing. Lord, I'm not there. But that's not the challenge here. That your Lordship will consider in another matter. Here, what have they done is, but that is being challenged. Your Lordship will adjudicate that. Here, my Lord, in this, now this matter is this matter. But in fact, this matter identical, my Lord, coordinate bench has already argued. But it's, it is, yes, my Lord, it is urgent. But I'm saying
Cannot wait for a day.
it can't. My Lord, they have extended it for 2 months. But what they are doing is tomorrow they are insisting us to file an agreement, undertaking. My Lord, we can't do that. My Lord, kindly tomorrow. Before your Lordship. But in that case, can I take the benefit of giving some more numbers also? It can be added to the list, similar matters.
Item number 9.
The numbers are given, my Lord. But in fact, orders are already passed, your Lordship.
Item number, my Lordship, kindly pass over the method. My senior is busy.
May I please, Lordship? Lordship, the examination is scheduled to be held on 8th of May. Thus, no notice will go, otherwise they have to come and respond in case. The university, my lords, MS Law University. Obliged, Lordship.
Item 10.
Already had this matter on 6th. Your Lordship had this matter, your Lordship posted it. Your Lordship posted it for a particular point. It is already, hearing is over. Because it is water supply matter and stay is cooperating since. Mr. Das was there on that. Oh, officer. Yes.
Now you have
The last topic wanted to know that sometimes there is some dates that is related to what we had with contractors. But at the point was
come tomorrow. Yeah, some matter.
Only difference can I mark it? Because
Tomorrow.
The officer has to come tomorrow. He has come today.
Tomorrow is already.
tomorrow is holiday.
Item number 11.
Yeah, will come.
Item 11.
Millard, IA number 1152 of 2026, item 11, sorry Millard, he has filed an IA for interim welfare.
Appellant filed a interlocutory application on account of his system.
There was some interregnum issue, so we have to.
My lord, yes, my lord.
He forgot everything.
Yes, I will.
But my friend, beginning, may I not just smite my lord's attention to the order of 24th of March. 24th of March, my lord. 26, my lord. Lord, we have filed an application in this matter, my lord would recollect, and my application for amendment was filed. And certain, I'm sorry, 24th of March. My lords, certain pleadings in the rejoinder, in the reply to the rejoinder. I wanted to know, I want those to be filed in IA. So my lord will only be here the IA along with the writ petition. So my lord, my only respectful submission is my lord can take my IA first, because if those are to be expunged, then my lords
Consider at the time of hearing. Whether to consider no document or not.
but then Lord, my lord will give me the liberty to point out when this.
Definitely, yes. We will take care of that.
Because
We will not rely on those documents.
I did not want to interrupt my friend when he refers to the document. That's why I thought I should mention it now. No, that is not because in the application for amendment, specific prayer was made.
If argument, you would definitely answer that these are not the specific document, these are not collaborated with city.
My lord.
Consider it
My lord.
at the time of hearing.
My lord allowed certain prayers and did not allow the other prayer. And certain documents were also next to the amendment application, which my lord did not permit.
Just invite our attention.
My lord.
My lord, reply to rejoinder is concerned, my OMC has already filed. Yesterday evening, I received my instructions to file the affidavit. We are filing it in course of the day. It will be a short affidavit and short copy on that. Yesterday evening, I received that instruction.
I think he was requested to come and he has taken a pain of coming. It was on a virtual mode on the last occasion.
Yes, my lord.
So senior persons, they are coming, and at the last moment you say, I have received the instruction yesterday to give a counter. You could have communicated to him that I am asking for.
No communication.
They would have arranged their.
No, but nothing.
The Supreme Court will have to circulate before.
Yes. That's the card they are playing. He's letting them.
I think they really have a role to play as far as my controversy is concerned. I can establish that.
But state definitely has a role to play. It is a state MOU which is got to be enforced.
Why you are censored?
He's appearing for the central. He's for the central government.
No, central government. He's the state.
Not find the counter for such a.
Central government तो नहीं है.
So
State
government is party. State government is party.
File that rejoinder
that was already a liberty given.
Central is not filing
They
anything.
have filed, but so far as state is concerned,
The senior
Which is his affidavit.
response to that. And these documents which are coming for the first time irrelevant, not admissible, those have to be expunged. So we will definitely take care of that.
Can I not start with this? Because your lordship, it should not trouble your lordship that I'm going to rely upon something which is not permitted to be relied. Let me deal with that first straight away. If your lordship feel that there is anything in that, your lordship will tell me I'll not rely on those documents. Just give me 2 minutes on that.
The difficulty is because when an expunction is sought for,
no, so your lordship
then,
have
in that event, the court will, at the time of an hearing, will definitely go into, because it cannot be done in isolation. It has to be done along with the hearing of the appeal. And the court finds that those documents cannot be taken into consideration for some reason or another. Then at the time of
final decision, your lordship will not rely.
Discard it. Then
you can decide the matter without that document. No, let me just explain what is the document. Let me just explain.
Part of the IF amendment. My lord.
Can I now answer my friend?
My friend.
See to it. Don't worry.
My lord, I have no doubt, my lord will.
See to it.
Can I just give it the right perspective? Then your lordship will appreciate whether these are any documents which should be relied upon or not. I file a writ petition, the original writ. I'm not talking about the amended writ petition for the time being. In the original writ petition, I make certain amendments with regard to promissory estoppel also without making a prayer. I make certain, that is why your lordship allow the amendment. I make certain amendments in the writ petition with regard to promissory estoppel without having a prayer. In regard to those amendments on promissory estoppel, they don't come and say that no, this promissory estoppel is not alive anymore, in spite of there being amendment. Let me just give in 2 minutes time. At that stage, Lord, when I realized that this is a case actually of promissory estoppel, I come for that amendment. Your lordships permit the amendment for the grounds and the prayer. There is no discussion on documents, and there is no need for your lordship to discuss. Your lordships are allowed a very limited amendment. Let me put it. They file a reply. So really speaking, once the writ is amended, a counter has to be called for, a rejoinder has to be called for. Now, the normal principle of pleading is, as I understand, my friend is much senior to me and he will understand much better than me, even before making this objection. A normal system of a pleading in any writ petition is that you rely upon certain documents in the writ petition. You give some documents in counter affidavit in response to what is relied in the writ petition. In rejoinder, I have a right to meet those documents which are relied upon you for the first time in the affidavit. I don't think there is any dispute on this. There can be any quarrel on this proposition. So my learned friend, in reply to the amended writ petition, places some document which he did not place in spite of the amendment on promissory estoppel being there in the original writ petition for the first time to the amended writ petition. Now, when he places some document for the first time in response to the amended writ petition, a rejoinder to that, I am placing some documents which are his documents, which are only showing that the reliance placed by him is not correct. That's all that I'm doing. Now, which law of pleadings says a rejoinder can't place document which is in response to a document which is placed in the counter? I don't understand. My experience is limited. My friend's experience is more. Your lordship's experience may be even more. Which pleading, which principle says that a rejoinder, a document cannot be placed on record in response to a new document being placed in the counter affidavit? If there is any such law, my learned friend should enlighten your lordships on that law, that there's rejoinder, you can't place any document. He is relying only on the fact that at the time of the amendment, I had placed these documents also. Your lordships only allowed the ground and the prayer, obviously, which is the normal thing.
I have told Suneta that at the time of a hearing of the matter, we have to just ascertain whether those documents have any bearing on
the real controversy issue.
Amended
That's right, Lord.
Or it has got any nexus or something.
That's all. That's all.
This is the only thing.
This is the only thing. Absolutely. Either you say it's a fabricated document.
We find it is irrelevant.
Your lordship will not deal with it. Your lordship will not. Absolutely. That's the law. That's something so basic. I don't have to even.
That is why now the problem is created by the state.
No, so state was not given the opportunity to file a sur rejoinder. That was only given to him. Please see your lordship's last order. It very clearly says they had asked for opportunity to file. Just see 24th of March. No.
Yes.
It says
My lord, senior can very well start the argument. Only that affidavit is essential because certain new points were raised.
What new point? The amended point. What new point?
They referred to certain agreements of 2004, 2009.
that is there in the original writ petition. Let me show from the original writ petition. It is there.
Already terminated, and it is in respect of two other different mines, and they want enforceability of those agreements so far as the present mines is concerned.
We will consider whether
Whether it can be given.
They are going beyond.
I may ask for the moon, but whether I can get it or not, your lordship have to decide.
See, if it is not touching upon the cause of action, which is initially.
Absolutely, Lord.
Only that formal objection, we are just putting it on record.
So for the sake of.
In course of the day, I just copy on my friend.
Yes.
So now, if I can come back to the main writ petition, Lord. This is a case where the history starts from 1997. That's how this whole case started. Of the state inviting Vedanta to come and invest in the state. It was ultimately captured.
It can't be an ancient history. It is a modern history.
It's a modern history, Lord. It's a modern history. So ultimately, this discussion, which started in 97, resulted in a MOU of 2003 between Vedanta and the state of Orissa. That please invest here, and when you invest, we'll give you certain facility. That MOU resulted in an agreement of 2004. MOU between the state of Orissa and Vedanta resulted in an agreement between Vedanta and the OMC in 2004. Now, in the 2004 agreement, I'm just giving very broadly, then I'll take your lordships to the document. There are three parts of that agreement. One part is that I will supply you bauxite, 150 million ton at a particular predetermined price. That is one part of the agreement.
With the state.
With the OMC, the agreement in 2004. There is another part of the agreement which talks of creating a joint venture company with me and the state of Orissa for the purposes of doing the mining, actual mining itself. That is, according to me, a separate part of the same agreement, that I will create a joint venture agreement. And the joint venture will do the mining. Now, Lord, I did all my part between 2007 and 2009 as far as setting up the smelter is concerned, or Lord, the refinery is concerned, which were my two obligations. I had a time limit also. If I do it within this time, for the refinery, I will get this price. If I do the smelter also, I will get half of that price, half of the royalty. So these are the timelines fixed in the agreement. I do my part. I set up the refinery. By now, Lord, I've invested more than 1 lakh crore in the state of Orissa. 1 lakh crore is my up to now. I do my part. As far as their forming the JBC is concerned, the matter travels to Supreme Court. And the Supreme Court says, we will agree only on the condition that Vedanta, apart from what it is obligated to do for the purposes of rehabilitation, will also do something extra. And Supreme Court says, if you are ready to do that extra, that is out of your profit, you take out a certain sum of percentage, also give some additional money, do X, Y, Z, do so much of employment to the local people, etc. Then only we will consider your approval for starting this mining activity. That was only with regard to mining. Smelter and refinery, of course, I had already invested. I went back to Supreme Court. They also were with me, and we all agreed that these conditions are acceptable to me. Completely. I was ready to reduce my profitability by 5%, and I was supposed to deposit a certain amount regularly, which was periodically, and I was also agreed to give certain minimum employment to the local people at that particular point of time, at that particular place. All that had happened. For some reason or the other, the environmental clearance was getting delayed. It was rejected at one stage. Then stage 1, stage 2 was also granted. Stage 1 was granted, stage 2 was not granted. At the stage of stage 2, there is an issue that the Gram Sabha had some role to play. Gram Sabha ultimately played a role and said that it can't be granted. Supreme Court said, all right, you go to the appellate authority, which is there is an appellate authority under the environmental scheme. The OMC has filed an appeal, which is pending, which OMC has done nothing about. Appeal against the Gram Sabha's order in terms of liberty granted by Supreme Court. All this was happening when the amendment to the MMRD Act happened in 2015. Now, 2015, when the amendment happened, they realized that now the joint venture can't do the mining. Was 74% has to be with the state. The joint venture will not prescribe less than 74%, more authority to the joint venture. So they said, you can't do the mining now. So the termination happened only qua the fact that I was to do the mining. Only I'll show that. And their subsequent conduct also I will show that in spite of the termination, they constituted a high part committee to see how my supplies can take place, notwithstanding the termination. I'll show all that. I'm just giving your lordship a very broad framework so that your lordship understand the objections, where are these objections coming from and what is the purpose of the objection. Objection is only to somehow defeat the hearing. So they constituted a committee where they said that we have to now look at how to ensure the supply happens to Vedanta because of the termination. And that resulted in that policy of 2018, where they started the supply at a rate higher than what was promised to be under the original agreement. I had been suffering from 2007 till 18 with zero supplies. 11 years, I had been buying mineral bauxite outside, and I had suffered thousands of crores of losses, which is all on record. At that stage, they give me a fig leaf, and they say, all right, that rate is not acceptable, you start at this rate, which is 200, 300 rupees extra than what I was originally entitled. I said, at least let me start with that. I agreed. I started with that. Then they at some stage realized, no, why should I take only 300 from him? I can extract thousands from him for this same bauxite. So they started tinkering with the policy. And when they started tinkering with the policy and they started wanting to make claims of not in 100 but in several thousands, then I decided not to file the amendment to the writ petition saying that please come back to your original promise. Your original promise was at this rate, if step 1 is done, and at this rate if step 2 is done. I have done step 1 and step 2 both in time, admittedly in time. No default on my part. If there is no default on my part, then I am entitled to 150 million tons of bauxite at the rate specified in the agreement, because I'll show from their conduct that notwithstanding the termination, they acknowledge after the termination also that they have to supply bauxite to me. This is the long and short of the story.
But are they taking the defense of a novation of a contract?
No, they are not saying that. Their only argument is that this 2004 agreement got terminated.
In the meantime, they have varied certain terms and you have agreed.
No, so they are not going that far. They are only saying that. So let me put back the principle of law first, and then promissory estoppel does not require a contract. That is the number one principle. Promissory estoppel does not require a concluded contract or a written contract.
Estoppel has a varied form. I mean, it may be by conduct, it may be by
Yes.
presentation.
So Supreme Court has said, and I'll take your lordships to those judgment, promissory estoppel does not require a contract. It can be by conduct. I am relying upon promissory estoppel by conduct, number one. Number two, as far as promissory estoppel is concerned, after Lord Motilal Padappan Udyog and all those line of decisions, earlier it used to be only a shield of defense. Now this court, the Supreme Court has said it can be a sword also, it can be a cause of action also. So it is a cause of action also, as far as promissory estoppel is concerned. And lastly, my lord, even for promissory estoppel, the only bar in very extreme cases, although even I'll show some judgment where even Lord the policy had changed, the taxability had started, sales tax had to be levied. Still Supreme Court said, no, now that you've made a promise, you have to continue that promise, notwithstanding the law having changed. In some very extreme cases, one or two, which are actually an aberration to the principle, also on very special facts, the Supreme Court has taken the view that if there is a change in statute completely, and there is a huge public interest involved, then promissory estoppel will not be enforced. Those are very, very, very special facts which I'll show. Rest the entire judgments plot right from high trees onwards. They have all taken the view that no, once you promise something to the citizen and the citizen acts upon that promise, alters his position. In fact, in some judgment, they say even if he doesn't alter the position, still promissory estoppel will bind the state. But here I've altered my position. I have made that investment. Having made that investment, you say, now, no. Now I'll extract my pound of flesh. Now, Lord, just to give your Lordship one more flavor before I start argument. If you are wanting to simply sell mineral, there is a situation where the state wants to sell mineral. Anybody can come and buy, a foreign company or even an outsider company can buy. It may be utilized in the state or not utilized in the state. If you are wanting to sell minerals simpliciter, then the only objective of the state is to maximize revenue, which is what has happened pursuant to the amendment to the MMRD Act of 2015. But if you are wanting to give mineral to an industry to set up in your state, then the consideration is not the value of the mineral. The consideration is employment. The consideration is tax that you create because of that. The consideration is ancillary industries that you create. So you may, on a larger scale, you may compromise on giving away maybe 1,000 rupees on the cost of mineral, but you may ultimately get maybe 10,000 rupees or 20,000 rupees in the ancillary benefits that you get by virtue of that industry coming here.
The larger public interest.
It's larger public interest. That's how this principle of promissory estoppel has been enunciated. That you have actually promised me. So every industry has a choice to set up here or set up somewhere else. Every state is willing to give all kinds of incentives to come and invest. Even today, I have placed on record, Gujarat is still giving to their local industries bauxite at 500 rupees. Even they, within this state, have given captive mines to Hindalco, who are not doing their own mining and they're spending only 400 to 500 rupees. This has been my consistent stand that they are having their captive mines and they are using that mineral for the purpose of, and it's such an unequal playing field. Just see, you have aluminum industries who are set up in the state, who have captive mines and who are getting the mines at 300, 400 rupees or maybe even less. And I have set up at your insistence. You promised that you'll give the mine to me. While you delayed because of that delay, this new amendment, this act. Actually, Lord, Your Lordship have done those other cases also. I was sitting the other day in court. Previously, Lord, the requirement of having the clearance, environmental clearance, was sometimes made mandatory, sometimes not made mandatory prior to the signing of the lease. At this time, it was mandatory. So since the environment clearance could go through, the lease could not be signed. If the lease had been signed in this case, there was no occasion for them to say that the amendment has come in. The amendment has come in only because of the delay, not at my fault. I have paid more than 140 crore towards afforestation and Campa, etc., which is still with them. 140 crore at the time when this environment clearance was sought. There is no default on my part. Supreme Court has cleared my case. Supreme Court says, I'll clear your case provided you do something much more than what is normally obliged to any industry to do. I agree to that also. In spite of this, if this has not gone through, it is because of their fault. Because they have not proceeded with that appeal that they filed against that Gram Sabha order that is still pending, even today. So now, Lord, since I've given you Lordship the background, now please see the document that I'm wanting to rely upon, Lord, the list of dates. In this list of date, I tried to capture most of the points that I'm making. I had given on the last date, Lord. I had given it to my friend also. हाँ यही बस 53 पेज ये वाला मोटा वाला हाँ 2 कॉपी होगा.
This one.
Yes, yes. Yes.
That's on the record of second. The second judge's copy. Yes. Second judge's copy. Yes. That's given. And
I'll give it.
Yes.
Now, these documents that my friend is so vociferously opposing, even the last day today also, are those documents which are in response to what they have said in their counter affidavit. If it is not relevant to their counter affidavit, so let me put it like this. I mean, if it's an objection, let it be dealt with properly. If you had the opportunity to place some documents in your original counter affidavit, and you have not done that, then why should you be permitted to place any more document, any new document in your amended writ petition? If the pleading was there, so if your document goes, my document also will. But if you had the opportunity to place that document at the time when the original writ petition was filed, because the pleading was there, and you didn't do it, then why should you be permitted to file any new document at this stage? If you are being permitted, because I am not being hyper-technical, I know it can be done. If you are being permitted to file any document, then I have a right to respond to those documents in my rejoinder affidavit to say that this document is really meaningless, because thereafter there is several correspondences with the state to show that this termination was only a technical termination because of the amendment to the MMRD Act in 2015. That also, your lordships are aware, came because of that common cause and that judgment of ML Sharma. So that has got nothing to do with, Lord, the promise. The promise is independent of that. Now, please see, Lord, the 7/6/2003. This is the first MOU which is signed. Of course, this refers to 1997. This was there in the original writ.
Yes.
Memorandum of Understanding entered into between Department of Steel and Mines, Government of Orissa, and Sterlite for a period of few years for setting up an aluminium refinery complex at Lanjigar, which would include setting up a 1 million ton plant's aluminium factory and 3 million ton per act of bauxite mining facilities, as well as the installation of 4 into 25 megawatt captive power plant at an aggregate investment of approximately 4,000 crore. In order to enable such large investment in the state of Orissa, the state government agreed to provide all health prevailing incentives and concessions as provided in the industrial policy and facilitate clearances necessary for the aforesaid project. The Orissa Mining Corporation to take necessary steps to execute an agreement with the Sterlite with the approval of the state government for all matters relating to bauxite mining lease. Notably, the transfer of mining lease from OMC to Sterlite would be considered only after Sterlite has made substantial physical and financial progress towards the implementation of the project to the satisfaction of the state government. Then, Lord, 8/6/2003, it is not there. Foundation stone was laid for the aluminium refinery was laid. Now, 5/10/2004 is the most crucial agreement. And this is there in the original writ petition also. This document was there in the original writ petition. And in response to this document, there is no averment that this is got cancelled. Because rightly so, because it was not cancelled as far as the supply of bauxite is concerned. Now, please see the original agreement. Just have a look at this document, Lord. Your Lordship will find at page 343 in the main writ petition, Annexure 12. Yes. 343, Lordship, Annexure 12. If your Lordship want the PDF page, it will be Lord 459.
Speak more. Many.
So,
Yes, yes. Yes.
Now, please see this agreement.
5th October 2004.
That's right. Now, Orissa Mining Corporation and Vedanta. Then please see 344. OMC has applied to the government of Orissa for separate mining leases under the provisions of the Appropriate Act and Rule in respect of Lanjigar mine as defined here and after and Kadulapur mine as defined here and after. Vedanta intends to set up an integrated aluminium complex in Orissa with an aluminium refinery of 1 million tons per year capacity in so-and-so in Kalahandi district to be catered by the above mentioned bauxite deposit in Lanjigar, along with another mine Both of such mines having a cumulative deposit of bauxite ore of 150 million ton, besides 6 into 120 megawatt captive power plant and aluminum smelter of about 2.2 lakh tons per year capacity at so and so in Jharsuguda district. These are all very, very backward districts. To help set up such aluminum complex in Orissa, OMC has decided and agreed to enter into a JVA with Vedanta on certain terms and conditions hereinafter set forth. In order to operate the Laljigarh mines and Karlapat mines, the parties agreed to set up a joint venture company on the principle of terms and conditions hereinafter set forth. It is the intention of the parties that bauxite mined from the mines as defined hereinafter be sold by OMC to Vedanta on principal terms and conditions hereinafter set forth. Now, Lord, please see, these are the definitions. Your Lordship, skip all that. Just see page 345, definitive agreement. There are 3 definitive agreements. Definitive agreements shall mean the agreements proposed to be entered into by the parties to give effect to the understandings contained herein, including, among others, a shareholder and share subscription agreement between OMC and Vedanta for and in relation to the JVC. Now, this is the one which is objectionable now after the amendment to the Act, not the rest. A raising contract agreement between JVC and OMC for in relation to raising of bauxite. And third is the most important, a long-term purchase agreement between Vedanta and OMC for purchase of bauxite mined from the mines. This can't be blood. This has nothing to do with this supply. They are supplying to me even now. So there is no question of this being a problem. Problem was with regard to the first, with regard to shareholder, because now, Lord, please see 346 raising cost. Raising cost shall mean the cost associated with mining of bauxite from the mines. So this is actually only the actual cost. Then, Lord, please see Article 2. The parties hereby agree to approach the government of Orissa for expediting the granting of mining leases in favor of OMC in respect of Lanjigarh and Karlapat. In the event a mining lease is not granted by government of Orissa for Karlapat, and why I am saying Karlapat, because Lanjigarh on the same day the mine is allotted. I'll just show that. That's the next document I'll show to you. In the event a mining lease is not granted by the government of Orissa for Karyapat mine, any other bauxite mine having at least an equal quantity of bauxite deposit, subject to having at least a composite quantity of 150 million ton, when taken along with Laljigarh, shall be made available by OMC with due approval of Government of India, Government of Orissa, and all references contained herein in respect of Karlapat mine shall apply mutatis mutandis to such other substitute mine as and when Vedanta proceeds to set up the integrated aluminum smelter in the state of Orissa. So the mine is not Laljigarh or Karlapat. Laljigarh, Karlapat, or if Karlapat has a problem, any other mine. That is the understanding is 150. That is determinative. Now please see, Lord, definition agreement is again the same definition agreement. You'll assume skip it, you not see the same thing. Just see 348 subclause 3. OMC will be allotted 26% of the issued and paid up equity share of the JVC in consideration of expenses incurred in respect of services rendered by OMC for operating the mines by the JVC as raising contractor, and 74% of the equity share capital will be with Vedanta. Now, this became a bar after 15. That 74% had to be with the state. Now, Lord, please see, the Lordship will skip all that. Now, come straight away to 349F. OMC shall allow JVC to operate the mining lease as raising contractor in respect of Lanjigarh mines without any let or hindrance for the period coterminous with the life of the mining lease, having obtained due approval from the competent authorities and authorities subject to following terms and conditions. On execution of mining lease, OMC will continue to lease in respect of mines to be operated by JVC. JVC, just before that also, Lord E. The JVC would take up exploration and exploitation of bauxite deposits of Lanjigarh exclusively for supplying bauxite to the refinery in Orissa and for no other purpose. So this mine, I'll show, Lord, there is another clause which says that it had to come only to me. Their policy which they are doing now, they do a 70-30. 70-30 is not permitted. 100% has to come to me. Now, Lord, please see that your lordship will find roles and obligations of JVC. OMC agrees to assist JVC, that is, Lord, I'm sorry, next page, 350, 350G. OMC agrees to assist the JVC on best endeavor basis without any binding legal obligation to enable the JVC to obtain requisite approvals to successfully implement the project envisaged under this agreement. And then, Lord, the most crucial part is the next page, which is at page 351. 2.3.3. Now, this your lordship will appreciate is relatable to the long-term purchase agreement, for which there is no bar. Your lordship saw there were three definitive agreements. One was the JVC, the other was not the share purchase, and this is the agreement to sale. Now, please see this water. The long-term purchase agreement between Vedanta and OMC. This is not JVC is not coming here at all. The long-term purchase agreement between Vedanta and OMC for purchase of bauxite mine, and the mine shall contain the following key provisions. Bauxite raised by the JVC shall be purchased by Vedanta by paying OMC an amount which will comprise 1. Raising cost, 2. A sum of money calculated in accordance with subparagraph B below, and 3. Royalty payable to the government of Orissa, and 4. Any other statutory dues payable by the state to the state government, central government, or any other constitutional statutory authority. Now, what is B? In the event and up to the time that only the refinery is operational, Vedanta shall pay to the OMC an amount equivalent to the royalty at the prevailing rate for every ton of bauxite mined. In the event and from the time when both the refinery and the aluminum smelter are operational, Vedanta shall pay to the OMC an amount equal to 50% of the prevailing rate of royalty for every ton of bauxite mined. Now, Lord, I have done both in time. And by the time I did this both, supplies had not started. My supply started only in 18. So for that 7 to 9, 2007 to 9, they could have charged me 100% of royalty. After 9, they could charge me only 50% of royalty. So this part of the agreement is not cancelled. I'll show to your lordship. This is something which is complete. What is cancelled is only the JVC of doing the mining, where 74% of the shares was to be kept with Vedanta, which was in terms of the JVC, and I'll show that. And that is why rightly they don't file anything in response to this agreement. Now, Lord, please see the next page, very, very crucial. D. Bauxite ore from the mines will be utilized exclusively in the proposed refinery, and OMC shall not sell the bauxite to any other person. This is the categorical finding, and I'll show, Lord, the next document which I'll show that the lease is also granted to OMC on the condition that 100% will come to us. So this is a very categorical, Lord, statement made in the agreement. This is also not cancelled, and I'll show from the subsequent conduct that is not cancelled. Then, Lord, the force majeure is in F. Just see that also, Lord. Subject to force majeure Vedanta to achieve any milestone as listed in Annexure 4 hereof for the activities mentioned therein due to the gross negligence or causes attributable directly to Vedanta, that OMC may give notice thereof to Vedanta. On receipt of such notice, the party shall discuss in good faith for a period of 60 days the options for obtaining the relevant approval or achieving the relevant milestones. And at any time after the expiry of period of 60 days, unless the parties otherwise agree, OMC may terminate this agreement with immediate effect by giving a written notice of such termination to Vedanta. It is clarified that during the period of 60 days, the obligation of the party shall continue to subsist on best effort basis. And then, Lord, condition precedent is coming into effect of the long-term purchase agreement shall be conditional upon completion of construction of the refinery, which I did in 2009. So, Lord, this is the agreement of 2004, which got cancelled. I'll show how a little later. Now, Lord, if your Lordship wants to come straight away now to the next document, which is, Lord, the grant order of 2004, that your Lordship will find it in the rejoinder affidavit at page 118. 120, sorry, Annexure 118, 120. This document, they are not asking expunging. In their application, they are not asking for expunging this. So just see what is this document. This is the document by which Lanjigarh was allocated to the Orissa Mining Corporation. Application dated 25/10/2000. Lordship have this document. Annexure Annexure 118, page 120 of the rejoinder.
Rejoinder you go, it's the filed by the prisoner.
Yes, yes, ma'am.
Or
4th or 5th of February 2026.
fourth or fifth.
He's saying 4th, she's saying 5th. I'm saying both the days. Either 4th or 5th, Lord. Maybe 4th February. 4th February 2026. 4th and 5th.
What is this? What is this annexure 120?
Annexure 120 plot is the state.
Is a
5/10/2004, the same day on which we did the agreement. Yes.
5/10/2000. Yes.
This is the same day when we did the agreement. Now, please see this letter, this annexure, which is this is not being sought to be expunged.
Double three.
Yeah.
Now, Lord, please see, this is from the government of Orissa to the OMC. Application dated 25/10/2000 of the Orissa Mining Corporation for mining lease for bauxite over an area of so and so in Lanjigarh. Now, please see the last two clauses of this. The grantee shall obtain forest and environmental clearance from MOEF, Government of India. Lots of that. And the next, most important, the entire quantity of bauxite to be raised from the mine shall be exclusively used in the proposed aluminium plant to be set up at Lanjigarh by Sterlite Vedanta Limited. And this I'll show continues even after the termination. This clause, it is mentioned in that document after the termination also. So there are two clauses. One is not grantee to get. So grantee substituted to me because after the JVC agreement, they said I will do it, which is why I went to Supreme Court. Supreme Court granted me permission. I'll show that. And the most important part is that 100% will come to me of this bauxite which is mined. Although this mine never started, but wherever they were supposed to give me whichever mines where they were to identify 150 million tons, whole of it was to be used to supply to me. After my supply finished, then only they could have gone and sold anywhere else. I'll show that from the other documents also. Now, if your Lordship will come back to the list of dates, serial number 4. Now, this is another memorandum of understanding which is executed on 4/4/2007 by the government of Orissa with Vedanta. Now, just see this document plot. That is also this is also there in the original. Yeah, this comes in their reply. Interestingly, this comes in their reply. They didn't place it with the counter affidavit. I also didn't place it.
Yeah.
I placed the agreement and I thought that was good enough for me. But they didn't say anything in response to that agreement that this stands terminated, which they should have done if they are so vociferously wanting to argue that that agreement had stood terminated.
Yes.
Snoblord, this document starts at page 32 of this is part of the counter. This is part of the counter affidavit to the amended writ petition.
Amended writ petition.
Amended writ petition. Reply to the amended writ petition filed on 9th January 2026.
Page?
In this plot, page 32. Annexure L.
Annexure L.
L. Page 32. Running page 32 of the
Yes.
counter affidavit.
Yes.
Now, Lord, please see, this is between again Vedanta and the government of Orissa. That is the opening part. And just see 33. In fact, the line starts from the line starts just above 33. Whereas VAL is desirous of setting up an integrated aluminum complex as mentioned in the table below, in detail comprising of refinery and captive power plant at Lanjigar and smelter at CPP so-and-so, Jharsuguda, in Orissa, which would include setting up an aluminium refinery having production capacity of 1 billion tons per annum, a captive power plant of so-and-so, an aluminum smelter having a production of so-and-so, and a captive power plant at an aggregate investment of approximately 8,400 crore. Then below after the table, now therefore in consideration of the foregoing and all other related factors, the government of Orissa and VAL have agreed and do hereby execute this MOU in order to enable such large investment in the state of Orissa. The aforesaid parties here to have agreed upon the terms and assurances set out herein above. Then Lord, in this, just see bauxite in the next page, 34, raw material.
Yes.
Orissa Mining Corporation will take necessary steps in executing an agreement with
you and with the approval of the government of Orissa.
That's right. For all matters relating to making bauxite available for the project. So,
availability of the bauxite to the project.
yes, so this is not spelling out the detail because detail is spelled out already in 2004. So they are reiterating that they will do everything to ensure that the bauxite is made available. And by that time, Lord, at page 35, Environment, Government of Orissa agrees to assist VAL in obtaining all clearances from the central government. Then please see 36, general clauses. Government of Orissa, number 2. Government of Orissa appreciates Vedanta is a responsible corporate house with a high involvement in employees' welfare and social development. Government of Orissa therefore understands that VAL will bring this philosophy to the aluminium refinery and captive power plant being set up in the district of so-and-so and the smelter plant in so-and-so to ensure the well-being of these districts in particular and people of Orissa in general. In the matter of employment, preference would be given to the people of Orissa as well as local persons subject to need and possessing necessary qualification. VAL would make every effort to improve their skill levels if necessary through specialized training for the purpose for which nodal agency or officer will be nominated. And then, Lord, please see 4. MOU shall remain valid for a period of 2 years from the date of signing. Further extension, if necessary, shall be made as per the agreement. However, no such extension shall be considered until VAL has made substantial progress on the implementation of the project in terms of the construction erection. So within 2 years, I did both the plants. And then 37, clause 7. In the event of non-implementation of the project or part thereof, the corresponding support or obligation of the government of Orissa indicated in the MOU with regard to bauxite or mines, coal blocks, incentives, concession shall be deemed to be withdrawn. And also they have admitted even after the termination, they are obliged to continue that support because of the investment made by me. I'll show that. MOU shall terminate if VAL commits any material breach, so MOU shall fail to make good, so. And then, Lord, clause 10, VAL shall effect sale of all its products and vices therein, so in the state of Orissa and shall not affect any breach, so. Towards its commitment to socio-economic development of the project and peripheral areas, VAL is committed to implement the stipulations of Government of Orissa in the notification dated 15 January 2004 of steel mines in respect of refinery and other facilities located in the scheduled areas of the state. As a responsible corporate entity, VAL shall also undertake suitable peripheral activities for the components of its project in non-scheduled areas in consultation with the local administration of the government of Orissa. And because of this plot, I have spent overall by now 1 lakh crore. Now, Lord, if your Lordship will come back to the list of date. If your Lordship will just see the note, Lord, of serial number 4 at page 4 of the list of dates. The 2007 MOU, therefore, saw the first footprints of setting up of the smelter plant located in Jharsuguda, Orissa, which today is the single largest end-to-end aluminium smelter in the world, except China, having a production capacity of 1.8 billion ton per annum, requiring 3.6 billion ton per annum of alumina, and consequently 11 million ton per annum of bauxite. annually and serving 40% of the country's aluminum production. This is what I am doing for the state of Orissa. So if you give me, even if you give me my full requirement of 11 billion ton, your 150 you will complete, because you've given me, by now you've given me about 20. So 130 still remains as per the original promise. It will go hardly in 10, 12 years, and again I will have to be dependent upon you for my future supplies. But at least I will be able to do this for these many years. Then, Lord, 2007, I filed the IA before the Supreme Court for the approval. Now, Lord, 2023, 11, 2007 is the Supreme Court judgment where they say we will not grant you clearance unless you do X, Y, Z. Just have a look at this, Lord. This, your Lordship will find at page rejoinder. This green is rejoinder. In the rejoinder, annexure 120, page 129. This also they are wanting expunged. This also Supreme Court judgment they want expunged. I don't understand who's drafting this kind of an application. Supreme Court judgment should be expunged. Do I need to report a judgment? Do I need to even ask permission to place a reported judgment to the Supreme Court? This is the careless or the blood. I would say I don't want to use a stronger word. So just see this judgment of the Supreme Court. This should be expunged. Now please see paragraph 4. Page 132, running page 132. It is not in dispute. I'm sorry.
Yes.
This is part of my rejoinder, and this is a document which they want to be expunged. A judgment of the Supreme Court. Reported judgment of the Supreme Court.
Paragraph 28.
No, Lord, I'm starting with paragraph 4 first. At page 132 of the rejoinder.
This is a TN Godawan judgment.
Yes. This is my application. This is my application to the Supreme Court asking for permission to give me forest clearance for starting this Laljigarh mining.
Yes.
It is not in dispute that in this case, mining of bauxite deposit is required to take place on the top of Niyamgiri Hills. MOEF has given environmental clearance for the aluminium refinery project. All requisite permissions have been obtained by the said applicant. The refinery to be constructed by Vedanta is 1 million ton aluminium refinery at Laljigarh.
Completion that everything has been done, 400 crores estimated cost.
Yes, the mining lease
agreement further indicates about the joint venture.
Yes.
And
the mining lease shall
appears in paragraph 1.
Yes. No, in this paragraph 4, last line is important, Lord.
Yes.
Mining lease shall stand in the name of OMC. The agreement between OMC and VAL indicates
they will sell it to VAL.
Yes. Agreement further indicates that the entire bauxite will come to VAL. Now, Lord, please see, this permission is granted with these very strict conditions. Just see paragraph 11. The special purpose vehicle is at the suggestion of the Supreme Court. The state of paragraph 11.1. The state of Orissa shall float a special purpose vehicle for the scheduled area development of Laljigarh, in which the stakeholders shall be state of Orissa, OMC and Sterlite. Such SPV shall be incorporated under the Companies Act. The accounts of the SPV will be prepared by the statutory auditors of the OMC, and they shall be audited by the Auditor General of the state of Orissa every year. CIL will deposit every year commencing from 1/4/2007 5% of its annual profit before tax and interest from Laljigarh, or 10 crore, whichever is higher.
That these components that would go for the development of those scheduled area, and you have to meet those requirements.
That's
there
right.
Will be a complete audit under their aegis.
Absolutely. No, something very interesting I want to show, Lord. Just pardon me 2 minutes, Lord, only this. The annual report of SBP shall be submitted to the CEC. CEC is the one created by the Central Impart Committee by the Supreme Court. If CEC finds non-utilization or utilization of funds, the same shall be brought to the notice of this court while calculating the annual profit before tax and interest. CIL shall do so on basis of market value of the material which is sold by OMC to the CIL or its nominee. In addition to what is stated above, SAIL shall pay NPV of rupees 55 crore and 50 crore towards wildlife management plan for the conservation and management of wildlife. NPV plot is the net present value. So whenever we do even a little bit of deforestation, there is a certain net present value which is that Campa fund. Lord, your lordship will recall, it goes to the Campa fund. There were thousands and thousands of crores. In addition, sales also bear expenses towards compensatory afforestation. Then, Lord, this says a statement shall be filed by SIL with CEC within 8 weeks from today, stating number of persons who shall be absorbed on permanent basis in SIL, including land users. They shall give categories in which they will be permanently absorbed. The list would also show particulars of person who would be employed by the contractors and the period for which they would be employed. The state government has the following suggestions. They gave some suggestions. Then, Lord, your lordship will come. If SIL is agreeable to the aforesaid rehabilitation, last para. If SIL is agreeable to the aforesaid rehabilitation package, then they shall be at liberty to. Sorry, para 12, last para of this segment.
Para 12, yes.
If SIL is agreeable to the aforesaid rehabilitation package, then they shall be at liberty to move this court by initiating proper application. This court is not against the project in principle. It only seeks safeguards by which we are able to protect nature, substance development. IEs are disposed of according. Now, Lord, please come back to the list of dates. Serial number 9. No. What's in number 9? This was serial number 6, which I just read.
Yes.
Then, Lord, we filed this IA at serial number 7, unconditionally accepting the rehabilitation package. That you will also find at serial number 7. Now, Lord, please see serial number 8 is something very interesting. Supreme Court says, this is again a reported judgment of the Supreme Court. Again, they want expunction should be removed from the paper book. Is the kind of, I would say, callous application made by them. In the same rejoinder.
Why you are using the word callous?
No, it is not fair to say that Supreme Court judgment should be
casual.
Not casual, but it's
Not
something.
cavalier.
I don't want to. I'll just leave it at that. Lord. Now, please see again at 142 is the averment that this has been accepted. It starts at 137 and paragraph 4 at 142. Lordship Sahib, paragraph
There
4.
was a rehabilitation package which was there.
The present IA, CIL
accepted without any condition.
Unconditionally. Now, please see something very, very interesting. Because of the fact that I was asked to give away profit and extra money, just see paragraph 12 of this very judgment. At the end of the accounting year of SIL, CEC finds that the annual profit before tax and interest is depressed by the pricing mechanism mentioned in the joint venture agreement of 5/10/2004, which is not that price plus 50%. Tax is depressed. Why clause point 2.3? Then it will be open to the CEC to move this court with its suggested price mechanism in its report. In fact, our order dated 23/11.
So there will be an audit which will be conducted by the.
No, I'm saying something else. The Supreme Court is visualizing that price may come down of bauxite because I'm asking you to do this extra. So price of bauxite may have to be reduced because if my profitability goes down, then price of bauxite. Today I'm not even asking for this. I'm only saying give me that price.
So what the Supreme Court says that if for any reason it has decreased
because of this extra that I'm asking, because the Supreme Court,
the additional impositions which have been made on
in the order of the Supreme Court,
then the Auditor General for the state will make a complete
and reduce.
And if it is found that something has been done, then
the bauxite price can go down.
It was given to approach the Supreme Court for the purpose of any further clarification.
That's right. So just can I read this whole para? There's only one para I want to read, Lord. If at the end of the accounting year of SIL, CEC finds that the annual profit before tax and interest is depressed by the pricing mechanism mentioned in the joint venture agreement of 5/10/2004 white clause 2.3.3a, then it would be open to the CEC to move this court with a suggested price mechanism in its report. In fact, our order dated 23/11/7, we had directed that accounts of SPB be audited by the Auditor General of the State of Orissa after they are prepared by the statutory orders of the OMC. It would be open even to the statutory order of OMC as well as CEC to inform this court at the end of the accounting year whether annual profit before tax and interest stands depressed for any reason. And at that stage, we will certainly consider price mechanisms suggested by CEC in the report. So it can reduce further because if it is found that the profitability is getting depressed. This is what I just want to point.
There was no liberty granted to you.
There was no liberty granted to me. So my price would be this, or it could be a little less if the profitability. I didn't have any role to decide that. That was to be decided on the basis of the CAG report, CAG of the state, to decide not whether my profitability is gone down or not. Now, please see. Now, Lord, please see the come back. The fellowship will kindly come back to the list or date, Lord. So clearance is granted now because I unconditionally agree. Serial number 9, Lord, stage 1 clearance is granted. Forest clearance is granted. Then, Lord, serial number 10 is another agreement between Sterlite and OMC. Just have a look at this document. This is there in their OMC reply also. It is there in the rejoinder also.
It's really a substitution, recognition of the.
That I have already done the investment. I just want to read just 1 or 2 paragraphs, Lord, in the.
Yes. So 2 clauses you are really relying on. One is the acknowledgement that you have already completed.
That's right, which is your lordship will find at the bottom of.
Refinery.
Yes.
And second, their commitment.
Yes.
Towards their obligation under the agreement of 5th October.
That's right. That's right. Page 57, Lord, is the reference to the 2004 agreement.
Yes.
And also it reiterates that the entire bauxite will come to me. And clause 4 says OMC's duties, responsibilities, rights and obligation in the said agreement dated 5th October 2004 shall remain unchanged and unmitigated. So this is a reiteration. Now, Lord Philosophy will come back to the list or date. I commissioned the refinery and the smelter in 2009, 7 and 9. That you will also find in serial number 11.
Yes.
Then serial number 12, this is the environmental clearance granted by the project. Then Lord 13 is the stage 2 forest clearance rejected by the MOU. The said rejection was challenged by OMC before the Supreme Court. And then Philosophy will see 18/4/13, Supreme Court referred the matter to the Gram Sabha. That's serial number 14. I'm not reading all documents because they are not relevant. Then Lord 15, Gram Sabha rejected the proposal. The Gram Sabha rejected and all this while I am suffering without any mineral. No mineral is given to me. Then Lord 8/1/14, in view of the rejection of the proposal by the Gram Sabha on 37/13, MOUF by order dated 8/1/14 again rejected the proposal for grant of stage 2 approval for forest clearance. Then Lord 17/9/14 is very, very important. This your lordship will kindly see their policy. This I'll show Lord how it is relevant here. Just this is also in the original writ petition. This is Lord at page 354 of the original writ at annexure 13. This is a government notification. Lordships have that, 354. Just see the second paragraph. Third line. Similarly, in the case of aluminium projects, Government has signed
Which
MOU.
Page.
I'm so sorry, not page 354, annexure 13.
No, this is the gazette notification.
Yes, yes. I just want
Of
to show the
17
second paragraph of
September.
that. Yes, yes, yes.
So-
Just the second paragraph, Lord, of this. 17 September 14.
Yes.
The fifth line, third line. Similarly, in the case of aluminium
Yes.
projects, government has signed MOU with few companies. These industries, having fulfilled their part of commitment, are expecting the state of government to fulfill its part of commitment, especially with reference to making arrangement for meeting their requirement of raw material. So they were alive in 14 that we have done our part, state has not done its part.
31 units, you are within that.
Yes, no, that is steel. We are not, third line is cutting us. Similarly, in case of aluminium projects, we
You
come
are
in the
not
third.
coming under that. 30.
That is the steel only.
Yes.
Now, Lordship will come back to the list of date. This is happening on 17/9/14, where they acknowledge that we have done our part. On 20/12/15, they give us a show cause notice. This is very interesting. 20th of February 15.
Yes.
This document is there in their reply. Acha, very interesting, Lord. Very, very interesting. This document is in their reply. But it is also in my rejoinder. They say expunge the rejoinder. This very document. They place it in the reply, but they are wanting expunging of this document from my rejoinder. So their reply should remain my same document should be expunged from the rejoinder. So this is a show cause notice without any substance, because it is saying as if we've done nothing and etc. etc. So your lordship will skip all that. Come to my reply, which I give to this reply to the rejoinder. That your lordship will find in the rejoinder at page 124.
No, this is show cause notice which was issued to you.
To me,
You have neglected and failed to perform your part of an
in
obligation.
spite of just 5 months before noticing that we have done our part, which is in the Gazette notification.
An agreement of 1997.
No, so in the Gazette notification, which I just read out of 17.
That I see that you saw that
They acknowledge that I've done my
there is an acknowledgement that they have fulfilled all their part.
all my part. Still, this show cause notice comes. So my response to this is at page 124. This is a little important. I want to read that. My reply में आ जाएगा. Page 155, Lord of my rejoinder.
Yes.
We are in receipt of show cause notice issued by the above letter cancelling the JV agreement signed between OMC and Vedanta, or any of the mines for Lanjigar and Koraput, as or any of the mines enabling OMC to supply 150 million tons. At the outset, we would like to clarify. I'm so sorry, my Lord, just this page 155 of the rejoinder.
Yes.
At the outset, we would like to clarify that there is no failure on the part of Vedanta in fulfilling its responsibility as per the agreement. And the same can be seen from the attached compliance report at lecture 4 to this JV. In this regard, we would like to bring to the following facts to your notice. As per clause C of the introduction of the agreement, the JV agreement is for operation of the mines. Accordingly, clause 2.3 of the definitive agreement was framed and is mentioned very clearly that JV shall come into operation subject to obtaining mining lease by OMC. Also, this was clarified at the period of mining operation, which states that JV shall be effective for the duration of the time during which JV undertakes excavation, exploration, exploitation, and development. OMC could not get the mining lease executed over the either Lanjigar or Tarlapat or any other mine, although we agree and appreciate that OMC has made efforts to get the mining lease executed, but could not achieve the same due to reasons beyond the control. Hence, OMC is free to excise its provision, but cannot hold Vedanta responsible for not fulfilling the responsibilities. You will agree that in spite of all uncertainties, Vedanta has invested more than 6,000 crore in setting up the Lanjigar Aluminium Refinery and commissioned the same in a record time of less than 30 months. The plant is being operated with outsourced bauxite, incurring huge losses which have accumulated till date to more than 3,000 crores. Additionally, Vedanta has invested more than 35,000 crore in setting up downstream facility, that is aluminium smelter, captive power plant at Jharsuguda, to meet the obligation as per the MOU agreement between OMC, so and so, so and so. Since no binding leases has been executed so far in favor of OMC, we have no objection if OMC would like to terminate the JV agreement, exercising its option as per the provisions of JV, but with the assurance that MOU between Government of Orissa and CIL for supply of 150 million ton of bauxite shall remain in force, as the requirement of investment in alumina factory and downstream investment have already been fulfilled. We would further like to place on record that it was only on the basis of the MOU for bauxite availability security for the refinery which resulted in the referred JV agreement. Such huge investment was made by us in Orissa. We take pride that in the last 1 decade, Vedanta has been the largest investor in Orissa, thereby creating large employment opportunities in the state, and we remain fully committed to the industrial development of the state. We accord priority to the local people of employment, and presently more than 65% of our workforce is from Orissa.
Now, you have said that what you have done generated the employment, direct and indirect.
And we say that you have failed in getting the mine.
What you
So
say.
you can't say that I am in default.
So far as the bauxite is concerned, you say that I do not, but so far as alumina is concerned, you have.
I have done my part. Now, Lord Philosophy will just see. Now, this amendment to the MMDR Act happened on 26th of March 2015. In the list of date, if Philosophy will see serial number 20.
Section 10A.
10A. 10A is inserted.
So all applications becomes ineligible.
No, so the correct clause is not quoted here. The correct clause is, if you will see the MMDR Act, which requires that it can only be given to an industry where 74% is government. Private should have less than 74%.
Where is that?
That is in the MMDR. I'll just show you. Just if you will have the MMDR Act. Where is the requirement of 74%? है लेफ्ट हैंड में नहीं गई वहां 17 just 1 second bro. capital A to B. 17 capital A to B. Where the government company or corporation is desired, Lordship have that? 17 capital A to B.
Yes.
Where the government company or corporation is desirous of carrying out the prospecting operations or mining operation in a joint venture with other person, the joint venture partner shall be selected through a competitive process, and such government company shall hold more than 74% of the paid up share capital, whereas it was just the opposite in our original. So this is the statutory limitation for the mining to be handed over to, not for the purpose of supply of bauxite to do. This is the only statutory limitation which comes in, and that too because of the delay which has happened. So this statutory limitation is utilized by them for the purpose of termination of the philosophy. Will come back to the list or date. So show cause notice is as if I have not done my part. I reply saying I have done my part. You have not been able to get it. You continue to give me bauxite from wherever, whichever means you do. I have no difficulty if you want to cancel that JV agreement as far as the mining is concerned. Then, Lord, please see serial number 21. In terms of clause 2.3.3F of the JV agreement, OMC requested petitioner to come for discussion at the OMC office on 24 regarding the show cause notice for termination. Now, Lord, please see next serial number 22. Though JV company was formed, but no bauxite. I'm reading from the list of date only. Though JV company was formed, but no bauxite was raised by OMC, was not provided with the lease of Lanjigar Karlapad, thereby completely frustrating the basis and foundation of for which Vedanta had agreed to make huge investment based on the commitment of the state OMC in MOU and JV for securing supply of 150 million ton of bauxite. The petitioner commissioned the aluminium refinery with CPP at Laljigarh and aluminium smelter with CPP at Jharsuguda. CPP block is the captive power plant. 2060 acres of land was acquired for setting up the refinery facility, awarding the best the land compensation and corresponding rehabilitation. Employment of 20,000 people, spending of 300 crore, creating of downstream and ancillary industries, contributing 2,500 crore to the exchequer. Unilateral termination of the agreement, which is only a document committing the supply of 150 million ton to the aluminium, will jeopardize the project of the plant and make the entire investment redundant. In this background, petitioner requested that the 2004 will be protected by keeping the commitment made therein for supply of 150 million tons. So this has been consistent.
Restricted only to a supply of 100.
I say whether you are able to do the JVC or not, if there is a statutory bar, I am not concerned. You just give me the supply. Then, Lord, I write to the Chief Secretary, which is the next document 23. This is, Lord, a letter from the Chief Secretary, Government of Orissa, to the Secretary, Government of India, with regard to, Lord, reviving this mine with regard to Laljigarh. Forest diversion proposal. Just see this document, Lord, at page 180 of the counter affidavit. OMC's counter affidavit.
So they just wanted to convey that we have decided to
do it ourselves.
JV, and now these are the imposition which has come, and he has done it for the cost of towards the cost of a wildlife management plan.
That's right.
And a tribal.
That is my money.
Yes, yes. That you have
paid by me. But they say we have paid it
really
on my behalf.
Augmenting many public causes.
Yes, yes.
So for
by
that,
using the money paid by me as if they have paid it for the purpose of reviving the forest.
The supply of a bauxite, it is the clarification.
That's right.
That how to do it. Then what happened?
In this letter, they also just see that one line only, Lord. Just see page 181, paragraph second last para. It may be mentioned here that aluminium refinery set up by Vedanta is facing acute shortage of bauxite ore, and it is in the interest of economic development to increase production of bauxite in the state. So it's all being done for me. My money being shown that I paid for this 140, that is all paid by me. Now, Lord, please.
One is the proposal. They want a clarification.
That's right. Now, please see the termination. That's the very next document. The termination happens on 30th of September. And that your lordship will find at page, this is also part of the counter affidavit. They didn't place it in the original petition reply. They place it in the counter affidavit at 194.
Yeah.
This has reference to the show cause notice of 20th of February for termination of JV agreement. So and so, so and so. Your reply, you have admitted that milestones 5, 7 and 9 have not been, the 5, 7 and 9 I show blood are only with regard to the JVC, not my achievement is all done. In reply, you have admitted that OMC made all possible efforts to get the mining lease and so and so, but same could not be achieved due to reasons beyond the control. In the meantime, more than 17 years have expired from the date of signing and 10 years from the date of joint venture agreement. In terms of the provision of the MMRD Act as amended by the MMRD Amendment of 15, the government company is required to have more than 74% ownership of the joint venture, and the JV partner is required to be selected through a competitive bidding process. So they say this statutory intervention has come.
So JV stands terminated.
JV stands. So my obligation, the very next document will show that they admit that they have to supply. Just see the next document, Lord. The next document your lordship will find at page. I make a representation to the Chief Minister, which is at Lord serial number 25, and see at serial number 26 of the list of date, 26. Just see at page, my lord, serial number 26. This is a gazette notification issued on 17/10/15 after the termination. Just see this. This is in the rejoinder. A gazette notification placed by me in the rejoinder because this termination issue is being brought in for the first time to say that because of the termination, I don't have any further right. Just see this document, my lord, at the rejoinder. 17th October 15. It will be page 167 of the rejoinder.
So they have said that so far as the JV agreements are concerned, it has stood concerned. The confirmation has also been done by the government. But there is a certain obligations that whatever the mining which would be done by the OMC.
Can I just read one line, Lord? It says, whereas the terms and conditions were issued for
This is
grant.
what I'm saying. So they have to continue supply you.
That's right. So the termination was nothing to do with my not giving me my.
According to you, it is restricted to the formation of a JV.
Where I was holding 74%. Because of the statutory intervention, it had to be, they had to be 74%, I had to be less than 74%. And
according to it is not in its entirety, but only restricted so far as the JV.
Only, so that agreement I said had three parts. One part was to do the mining through the JVC. That part only has gone, and this document, which is after the termination, shows that the state is alive and it has to supply. It says so. Your Lordship will, we still have time, sorry. Just see this, just can I read this document, not at page 167 of the rejoinder.
Yes.
17th October 2015, this is not at page 167. And this is a document after the termination.
Yes.
Whereas terms and conditions were issued, second paragraph. Whereas terms and conditions were issued for grant of mining lease for bauxite over an area of 721 hectares in Lanjigar of OMC with an additional condition that entire quantity of bauxite to be raised from the area shall be exclusively used in the proposed alumina plant to be set up at Lanjigar by Sterlite, that is Vedanta, whereas under the provisions of the amended MMRD, it would not be permissible for the government to allow transfer of mine of OMC to JVC with controlling stake of private parties. Whereas Sterlite has set up the refinery at Lanjigar.
So they have constituted a committee to take care of all these things.
This committee is constituted because the termination has happened, and termination is limited qua the 74% holding of my lot stake in the JVC, and which by law could not have been done. So they say, but we still have to supply you the bauxite. So this high part committee, which is not headed by the chief secretary, is set up only to ensure how my supplies will happen. Now, please note one more thing, not very important. We are now in 15. My refinery came in 7, my smelter came in 9. Till date, 0 ton supplied. This is the, and I'm repeatedly saying that at 3,000 crore, 5,000 crore, because I have to buy bauxite at very, very high prices. So I'm suffering these losses. Please start this supply. So I'm in that very, very unequal bargaining position, because what happens thereafter is not a reflection of that. I just read that. Sterlite and Vedanta has set up the refinery and is now left without any assured source of raw material, which is in this document. Now, Lord, if your Lordship will come back to the list of date. Serial number 27. I know. There is the list of date. We write, Lord, again to the Chief Secretary after this committee is constituted, because this committee is headed by the Chief Secretary. The JV agreement with OMC not only assured 150 million ton, this agreement also
say that it not only contains the supply, but also the pricing component is also included.
Included in the agreement.
So now, once you have decided that you will not go ahead with the JV, now these parts.
Please supply me, supply me the bauxite at the price which has been promised to me. So this is a very detailed letter, and I say in this very letter, Lord, that till date I have suffered 4,300 crore.
What you have said already, and you have invested a huge
amount of money, and I am losing 3 crore per day because of the difference. What I am saying, Lord, 3 crore per day is the difference at which I am buying the mineral from outside vis-a-vis at the rate at which I was promised under the original 2004 agreement. None of the replies to these letters, which happened all after the termination, they say that you are not entitled to any more because the agreement is. So the stand that they are wanting to take in the amended reply to the amended writ petition, as if everything went away after the termination happened, and my rights to get bauxite also go. That's the kind of argument that is sought to be canvassed, and they want to do this argument by tying my hands at the back that I will put whatever documents I want to, but you can't put any document in response to show documents which are their gazette notifications, which show this what I read to your lordships is a gazette notification forming this committee to ensure my supplies happen after the termination. They are objecting to that gazette notification being placed on record. They are objecting to Supreme Court judgments being placed on record. That's the kind of, I'm not wanting to use any adjective for that, but legally not permissible. Then, Lord, please, there is one more very important judgment of the Supreme Court which happens thereafter, which I'll read, Lord, probably after lunch. Then, Lord, 28. Applicant was given an opportunity to present his case before the committee formed by the state. Pursuant to that, the petitioner also issued a letter to the Chief Secretary. We are confident that the committee must have realized the gravity of the situation and make suitable recommendation for the long-term supply of bauxite to our aluminium refinery at Lanjigarh. Then the next paragraph, at this juncture of difficulties, we have complete faith in the Honorable Committee.
We have invited the attention of the Chief Secretary.
Who was heading that committee? It was constituted after the termination.
What are you facing, and how it is not viable if you do not step in?
Because it is not only viable as far as the plant is concerned. Lord, I have done so much of ancillary industries in that area, so much of development I have done in that area, so much of employment I have generated in that area. So all that was on this assurance. I went to, I don't know whether your Lordship have had the opportunity. My father was posted here, so I've been to that area. My father was posted in Berhampur long back in the 70s. So I've been to this Kalahandi and all these areas I've been to. It was one of the very, very backward. I don't know if your Lordship have had the opportunity to be there. So this plant was set up in an area where there was absolutely nothing. It was like a complete raw, as if we are still living in primitive age. Roads have come, employment has come, schools have come, houses have come for these people. All that has come because of this industry. Then, Lord, we say that you please rescue our Lanjigarh operation from being economically unviable. Also send a right signal to the investor community, confirming the support of Government of Orissa and retaining and promoting the current future investment in the state. So, your Lordships have seen, I showed on the very first date, that there are states ranked in this country of Lord where people feel confident to invest. And Orissa comes at the bottom. The top states are Maharashtra and Gujarat. Because if they make a commitment, they follow that commitment. And that is how Lord more and more investments come in. Here they don't want to follow their commitment. They want to, one hen which is giving these golden eggs, they want to twist the neck of this hen and take away all the eggs as if they'll get all the eggs at one go. In spite of letting the egg,
Lord, the story of a golden goose.
Golden goose. So they want to, Lord, take all the eggs at one go and kill the goose in the process, which is what this state is wanting to do in this case. I'll not take much time, Lord, after that should move to the speech. I'm relying upon, but I'll read only some of them.
Justice Chandrachud's judgment is also the last one I could come across on a promissory stop.
Yes, the recent one, yes.
Thereafter, I don't know whether any other.
No, I don't think there is one, but basically that Motilal, Padampat, Indo-Afghan, they've all been, they've still been confirmed. In fact, there is an interesting judgment, Lord, of the Bombay High Court prior to independence, where, Lord, a land was given to the municipality on the ground that they will surrender some land. And then after 30 years, they wanted to cancel the lease or ask for an enhanced premium. Even that was said can't be done. If you relocated somebody and without there was nothing in writing.
With the first matter. It is already at the first matter. Yes. And here.
So, Lord, I just read this gazette notification of 17/10/15, which clearly shows that they were wanting to honor their commitment. There's no question of going back on that
Including a
commitment.
high power committee.
Yes. Now, Lord, only one document, only one part did not read. I just want to read that. Just see this document at page 168 of the rejoinder. 13th November 2015.
Yes.
Annexure 129. This is our letter.
Paragraph 2 and 3 is important.
Yes, no, and please see paragraph 2. Yes,
2 and 3.
page 169. Yes, we would like to also try to bring to the notice of the committee that
You have
all other.
recommended the formation of the committee. Yes.
No, that is one. And the next page, there is a paragraph 2 again, Lord, at page 169. We would also like to bring to the knowledge of the committee that all other alumina producers in the state.
That you have made a largest investor.
And they have got large captive bauxite mines. And Vedanta has made the largest investment in the state based on repeated assurance of bauxite on terms and conditions agreed previously. Therefore, absence of a firm commitment of bauxite supply in line with the JB agreement will be discriminatory. And then if you Lordship will see the last para, hope your good self understand our pain and difficulty and take necessary steps to honor the terms and conditions of the JB agreement to assure us 150 tons by the end of so and so and service.
Participation you wanted with the committee.
That's right. So the committee is formed for this purpose, and the committee is deliberating. I am putting my input that look here, why I have always been consistently making this demand. I have done my part. What has not been possible is unrelated to me. That is because of either the amendment in the law or because the environment clearances, etc., were held up at some stage. I am not in default as far as any of that is concerned. Now, Lord, if your Lordship will come back to the list of date. Serial number 29. This is again very important. Just have a look at this document, Lord. This will be page 182 of the reply. OMC reply. So your Lordships are aware, Lord, that as far as the, can I just take your Lordships to the MMRD Act once again, Lord, just for a limited purpose, only to show the if your Lordship will kindly have, Lord, the MMRD Act, and then I want to read this document because there is something very important in this. Just kindly have the MMRD Act, Lord. Just see section 4.3 first. 4.3. Four 3 will apply if the state government wants to do mining through its own department. That is 4.3. And this was there in the earlier, the unamended act also, it's here also. Any state government may, after prior consultation, not approval, unlike in 5.1, with the central government and in accordance with the rule made under 9.18, undertake reconnaissance, prospecting or mining operations with respect to any mineral specified in first schedule in any area within that state, which is not already held under the mineral concession. So,
Power state government
to do it itself. Now, let please see 5.1.
Yes.
5.1 is where some private person has to do it.
Not to any person.
To grant it. Now, please see 17 capital A. 17 capital A. 2. So there are three ways in which mining can be done: either state itself, or under 5(1), and under by notification if it wants to give to a public sector, state public sector unit. The state government may, with the previous approved central government,
Government or
control.
semi-government
That's
or
right.
anyone
That's right.
controlled by.
So now this I showed to your lordships in 2004. The state has given it to OMC in 2004. That will be a conferment under 17A, and 10A 2C does not apply to 17A. It only applies to 5(1). Just have a look at 10A 2C. So this is a completely erroneous legal understanding of the OMC as far as this particular mine is concerned. Because at some place in the reply they say that 2-year period has expired. Just see 10A 2C, 10 capital A 2C, where that 2-year window has been created. Lordships of 10A 2C, where the central government has communicated previous approval as required under subsection 1 of 5, not of 3 or 4 or 17A2. And if a letter of intent so and so is not given, the mining lease shall be granted subject to fulfillment of condition previous approval so and so within a period of 2 years from the date of commencement. This 2-year doesn't apply in 17A as it then stood. 17A as it stands now after the amendment, because this is a case of 17A exercise prior to the 2015 amendment. After 2015 amendment, 17A also has a 5-year period and also has a power to relax. But we will not be covered because we will be covered by the 17A as it stood prior to. Have you got a hard copy of 17A? So 17A ka pura. I have got the 17A, previous 17A, Lord. That is prior to 15. Just have a look at that. (17A2). The state government may, I'm sorry.
Yes.
The state government may, with the approval of the central government, reserve any area not already held under any prospective or mining license for undertaking prospecting or mining operations through a government company or a corporation owned or controlled by it, and where it proposes to do so by notification, the official gets specify the boundaries of such area and the mineral in respect of which such areas will be reserved. Now 17A, if your lordship will see, are having only these 3 subsections, actually 4 subsections, 1, 1A, 2 and 3. Now there is a 5-year restriction which is added after 15. That restriction is not there. This is really speaking not arising here, but it is arising in the sense that in the reply they say that Laljigarh has gone. Laljigarh has gone, so now the lease has not been executed within 2 years. So really speaking, how do I supply you? I don't have Laljigarh. That's the argument. Although, if your lordship will recall in the 2004 agreement, it says Laljigarh, Kariapat or any other mine, 150 million ton you have to supply. So it doesn't restrict itself to Laljigarh. It says Laljigarh, Kariapat or any other mine, total should be 150 million ton. So this argument of theirs that Laljigarh has gone because lease was not signed within 2 years actually also fallacious, because this is a grant under 17A and 17A has no limitation period as then existing. If it is a post grant lot, post 15, then it will have a 5-year restriction, because the new act, just have a look at the new act also, while your lordships are on this act. Just see 17A now new. That will be in the book. Subsection 4. The reservation made under this section. So this section obviously will be the amended section, because earlier section didn't have 4. The reservation made under this section shall lapse in case no mining lease is granted within a period of 5 years from the date of such a reservation. Although there is a power to relax also, but your lordships are not considered, not required to consider all this, because this is a 2004 grant in the favor of the state PSU. And for this purpose, the letter that I'm going to show to your lordships is very, very important. legal understanding of the central government also. That is the next document. Even this subsection 4, my junior points out, my friend points out, this is also of insertion of 21. It was not there even in when the section came. Subsection 4, if your lordship will see, this was inserted by Act 16 of 21, that is 28/3/21. Now, Lord, if your lordship will come to the next document which I want to show, that is at serial number 29, but the document is at 182 of the reply of OMC. Annexure T1. Annexure T1. Page 182 of the reply of the OMC.
Yes.
Now, 182 of the reply of OMC. If your lordship on the PDF page, it will be 184 of the reply. 184 of the reply of OMC. The reply filed on of the amended.
Yes.
9th January 26. 9th January 26. It's actually opened here. I think that's the. This document is opened on the screen, Lord. No, it is the 20th January 16. No, sorry, Lord. 182, not this.
That is not there in your rejoinder. This counter
No, that is not, that is in their reply only.
counter affidavit 9th.
9th January 26, counter affidavit filed by OMC. In that document at page 182.
182 is
Government of India, Ministry of Environment and Forest.
what is that document dated?
20th January 16.
Who are you are opposite party number 1?
No, I think OP number 1.
Yes, yes, opposite party number 1.
Orissa Mining Corporation.
Page 182, Lord. PDF 184. 3234 in the complete bundle.
3234. 3234. 20th January.
That's right, Lord. Now, please see, this is a letter.
Annexure T1.
That's right, T1. I'm so blind. So, this is a letter by the Government of India, Ministry of Environment and Forest. Now, why is this relevant? By this time, the amendment has come. By this time, if they are saying that the mine has gone, this is of 16, much after the amendment. Now, please see what is the letter. I am directed to refer to the Chief Secretary, Government of Orissa's letter dated 19 September 2015 on the above mentioned subject, wherein this ministry was requested to clarify whether forest diversion proposal of Mrs. Orissa Mining Corporation for diversion of so and so for Kalahandi and Raigada districts for bauxite mining in Lanjigarh may be revived from stage 1 onwards, or whether fresh diversion proposal is to be submitted to the ministry by the project proponent. The matter has been examined by this ministry in consultation with Ministry of Law and Justice. The advice of the Attorney General has been obtained. After careful examination of the matter and on the basis of advice of the Attorney General, I am directed to say as below. It is not possible for this ministry to revive the old proposal. A fresh proposal for diversion will have to be made by the Government of Orissa to the ministry, containing salient features and the factum as to how it will be different from the proposal.
Which says that everything which was done at that.
You have to start all over again.
Start
Point that I am making is.
And very interesting that an observer be appointed by the High Court.
That's right. The government is saying that it should be appointed because there is not that Gram Sabha issue. So they don't want that because your lordship must have seen there is a little bit of resistance. So it should be appointed by the High Court. Now, this they have taken no steps on. to say that I will not give it to you because Laljigar has not happened. What have you done in spite of all this? Government of India is saying that you go ahead and do it. My money is still lying with you, 140 crore. You claim that, and their letter actually says that my 140 crore is lying. Let me revive that proposal. So government says, no question of revival. You have to make a fresh up. They do nothing about that. So I'm only trying to say that that defense that Laljigar mining did not happen, because of which I'm not obliged to supply bauxite to me, is completely defenseless. Because if it has not happened, it is your default. Even the government of India is saying that you please go ahead, and they have done nothing. Their approval with the state committee is still pending, not against the Gram Sabha decision. They are not proceeding. It's pending for the last, I believe, 7-8 years. The very next document in the list on date, your lordship will see, is their appeal. Serial number 30.
So
Serial
they
number
challenge-
30.
This challenge before the Supreme Court.
Yes. Now Supreme Court grants them permission. I'll just show that. That comes later. Then Lord 4316. Now this is interesting. 31 is very, very interesting. Please see 31. 31 is Lord a amendment to the mineral auction rules, which talks of 45 formula for calculating average sale price of metallurgical grade bauxite to be used in alumina and aluminum extraction of so and so, so and so. Now this is very, very important, because this rule, in spite of coming in the statute on 4th March 16, they never applied it as far as fixing the base price for me is concerned. Why I'm saying this? Because there is a little which your lordship will see later on. When this rule came, they don't apply this. They start giving me at plot the price plus 50% profit, which is higher than what they had promised to me. Sometime in 19, when this rule is further amended, they start saying that I'm bound by this rule. That I'm bound by this rule, and that has to be the base price from which the auction will have to, floor price for the auction. But just note this, that this rule comes for the first time in 16 on price of bauxite. Then Lord 32 is the permission of the Supreme Court. This IA of the OMC is listed before the Supreme Court. We leave it open.
You go to the appropriate forum.
To the aggrieved party to challenge the decision of the Gram Sabha and consequent decision with regard to environment clearance before the appropriate forum. And then, Lord, to the very next document at 33, these appeals are filed. In 16, several appeals under 6(2) of the
pending.
These are pending till date. These appeals remain pending. Therefore, the assertion by the OMC that grant has become infructuous under 10A2C is legally untenable, as vested right was created in favor of OMC by the grant of 2004, long before the 15th Amendment. Whereas the petitioner has continuously shown its cooperation by undertaking the rehabilitation package formulated by the Supreme Court, making an overall payment of 140 crore, which includes 55 crore towards net present value, 50 crore towards wildlife management plan, 12 crore towards tribal development, 2 crore towards compensatory afforestation, and is still willing to continue with its commitment towards the refinery plant as well as smelter. The state OMC cannot now be permitted to take advantage of its own wrong of not pursuing the appeal before the SLDC with regard to starting the mining operation at Laljigar by their inaction. So I'll show the reply where they say that Laljigar never came, so my commitment to you has gone, which is fault on two grounds. Firstly, didn't come because of your default, and secondly, your liability was supplied Laljigar, Karyapat, or any other mine. Then, Lord, please see the next. Now, let's just see that serial number 34. After 11 years of starving me from bauxite and making me buy from the market, they come up with this policy. And why this is important? Because in the Motilal Padampat Udyog, one question also was raised about waiver. And Supreme Court says there can be no waiver, it has to be pleaded. And in spite of this, so this policy was very similar to what was promised to me, priced slightly higher than what was originally promised to me. I accepted this promise because I was not in a position to, not in spite of my, and I'll show even after this, I have been saying the same thing, that my price is fixed and my 150 million ton should come. But this is the first ray of hope for me to start getting some supplies. Now, please see what they do in this. This is an amendment to the 2014 policy, and here for the first time they included bauxite. Now, just see that I've quoted the relevant parts. Your Lordship may not go to the document. 70% of the saleable stock shall be made available for long-term linkage to the state-based end users, and remaining 30% shall be sold through national e-auction done every 6 months for price discovery. Now, I just pause here for a minute. This 70-30, they had no right to do. Right from the grant till the agreement and thereafter. 100% was to come to me. So this 70-30 is firstly, that is the first illegality. Then please see next. Weighted average price arrived at from the national e-auction shall be the long-term linkage price for the appropriate grade of mineral, state-based end user plant and take plant in the auction. Floor price of the national e-auction may be fixed at the cost of production plus margin of profit 50%. Now, this cost of production plus margin of profit 50% is more than the cost of production plus 50% royalty. In my case, it had to be 50%. You Lordship have seen the agreement. It says cost of production plus
The moment you set up the smelter, then it will reduce to
50%. And
till the time the others
2 years, it was 100% of royalty. So either 100% royalty and after smelter, not 50% of royalty. This is changed to 50% profit, because of which this amount goes higher. But after having run for 11 years in pillar to post and running after everyone, I don't have a choice. So I said, all right, let me start with this. So I start with this. Instead of continuing with the commitment as per 3 and 4, the state notified the 18 policy which changed the mechanism of quantity and pricing provided under so-and-so, inserted bauxite linkage for long term. Now, two irregularities happened. Firstly, 70-30, which could not have happened. And secondly, this price, which was wrongly fixed. Then, OMC published the next 35. OMC published the expression of interest for long-term linkage OMC for a period of 5 years by state-based end users for purchase of bauxite. The issuance of 18 policy signifies that intent of firm pricing mechanism of bauxite sale was clearly envisaged by OMC, where floor price for national e-auction was fixed at the cost of production plus 50% profit. Then, 14.3.18, petitioner wrote to the AMC seeking continued support of bauxite security to the Laljigar Alumina Refinery and for entering into an LTL with the petitioner in line with the 18 policy. Vidinta undertook that it shall pay the price as such or as had been discovered by national e-auction. Further, it was confirmed to pay specified weighted average price arrived at from the national e-auction towards the appropriate grade mineral lifted under the long-term. Vedanta also stated that, and then we said the whole thing once again. We have invested by then our investment had gone up to 42,000 crores in Orissa for setting up state-of-the-art aluminium factories, so world-class aluminum and power complex by creating 50,000 direct and indirect jobs and large-scale business opportunities.
You have reduced the direct and indirect.
No, it is actually growing. Finally, today it is. No.
Earlier you say 1 lakh.
No. So this is
1,000. Though investment goes up.
1 lakh is now. That I'll show 1 lakh. I say now. By now it is 1 lakh. The said investment was possible based on the firm assurance made by the state government to make 150 million ton of bauxite available. Ranji partially almost for a decade by sourcing bauxite for external source, whereas our peers in the industry are able to. And here also I say that in the very state of Orissa, the other aluminium manufacturers like Birlas, etc., Hindalco, are getting bauxite from their captive mine where they are paying only 2 to 300 rupees effectively, which is the cost of extraction and the royalty. That's all that they're paying. And then again, we say that just see the note. Petitioner having already invested substantially and corresponded repeatedly with the state and OMC persistently through commencement of the bauxite supply. The first viable prospect of supply arose with the LTL policy of 15. Given the limited bargaining power, urgent need to begin operations, the petitioner was compelled to accept this policy, notwithstanding that its pricing was slightly higher than as promised in the 2004 agreement. Then, in fact, in 15, I had said that our employment is about 20,000. Now it has gone to 50,000. Then, please see 1838. Serial number 38. Please see serial number 38. Your Lordship want to see that is at serial number 25 of 20,000 employment.
You are referring to a document where you have said something.
No, I have said that I am giving employment to 2 lakh people and impacting the life of more than 1 lakh. So that's how I said. Because each employee, each person employed will have a family of 4 5 people. So I am saying impacting one. Serial number 25. Then, Lord, please see at serial number 37. First national e-auction was held. The floor price was 462. Auction was successful as 465, that is for 30%. So they gave me at 465. And I agreed also to take 465. Then, Lord, this next document 38, long-term linkage sales agreement for bauxite was executed between OMC and petitioner for the sale of bauxite. Period 18 to 23, annual sales quantity so. And then please see the underlined portion. The weighted average price of a product derived from the national e-auction will be fixed on the sales price of the particular product to be sold. Therefore, long-term sale price will be changing continuously with each auction. Then, Lord, the second auction happens on serial number 39, which is 31018. This LTL agreement is pursuant to the LTL.
553.
Yes, 553. 548 is the
Which you also accepted.
which also I accepted. Then, Lord, third auction is third national auction is 673 is the floor price and 673 is the discovered price also. Even this I accepted. Then, Lord, what they did was they came with the 2019 policy. Just see this also, very important. Was while this policy was in vogue, they became dishonest. Even they wanted to go out of this policy. This policy, your Lordship will find at page 399 of the original writ petition. So first amendment came to the 14 policy in 18, and now there is a 19 policy which is coming.
Yes.
Now in this 19 policy, please see, Lord, at page page 406 of that same petition, original writ petition. So this document starts at, Lord, page 399, which is the 19 policy
No, come to the writ petition.
of the writ petition. Yes, Lord. 399.
Go down.
Computer page 490.
No, it's come 399. This is what the document is. Annexure 17.
Annexure 18. Annexure
390,
18.
Do it.
Computer page 490. Yes. Nice. 490.
Annexure 18, Lord.
Yes, I got it.
Annexure 18. Now that starts at 399. Just come to, Lord, 406.
That is the 10/7/2019.
That's right.
401 heading is
Now see 406.
401. Heading is long-term linkage.
Yes. Long-term linkage policy.
That's right. Now please see bauxite comes at page 406. Again, clause A says 70% will be through long-term linkage and 30% through national e-auction. Again, this is not permitted under the grant to them as well as not the subsequent documents created. Now, please see price. Floor price for national e-auction may be fixed at the cost of production plus margin of profit. Same thing. Now, in spite of this coming, they become, because there is a further amendment to that rule 45, so they don't do any auction. Serial number 42. No auction happens. Serial number 43, again no auction happens. Complete stoppage of supply. Then, Lord, this amendment happens on 20th of September 19. The rule was there from before. There is a conversion factor which is notified. Now, just to explain in simple terms, as per the original rule, the price of bauxite would be around 25,000 rupees. 25,000 rupees. As per the factor now introduced, it comes to around 3,000 rupees. So this factor is this. There is a modified factor. Just see not this rule. Just to make it simple, because I don't really want this issue is not in this writ petition. There is a separate writ petition challenging this here as well as in the Delhi High Court. But just see Rule 45 is quoted here. Formula for calculating average sale price of metallurgical grade bauxite to be used in alumina or aluminium extraction limestone so and so. The following sub rule shall be substituted. The state government shall arrive at the average sale price of metallurgical grade bauxite in the following manner. And there is a formula. And what is added is after IBM into conversion factor as notified by the central government. This is added in 19. Prior to this, there was no conversion factor. And why not a notification of the same date conversion factor has been stipulated at 6.4%, which was not there in the formula prior to the amendment. So when this rule came in 16, this 6.4 factor was not there. So this 6.4, without the 6.4 factor, the average price would be around 25,000-30,000. Now with this 6.4, it comes down about 2,000-3,000 rupees. So then we file our first writ petition. So when we file our first writ petition, we basically are saying that, look here, there is a policy now which says price will be the raising cost and 50% profit. Oh, this 45 is the Delhi High Court challenging this conversion factor, which is still pending. Then please see at 46, we are still struggling for getting any supplies. The auction was put on hold. Then we make a representation. Then Lord, 48 is very, very important. Just see what the government of Orissa writes to the Ministry of Mines. That document you will find in the writ petition at page 445, annexure 25. By this time, that conversion factor has already come. And the government of Orissa is writing to the government of India, Ministry of Mines. Lordship, 445. The entire of it.
Yes.
The LOD doesn't have the whole of it, so can I invite your lordships to 445, which is the original document in the writ petition. This is part of the original writ petition. PDF page number 536.
No, that's right.
The Aluminium Association of India and OMC, the state PSU, have represented for revisiting the formula of ASP calculated based on the notified formula on the ground that the same appears to be unrealistic. The said association has further stated that formula, if not revised, may affect economy of aluminium industries. The matter has been examined and it is observed that ASP as per the formula prescribed by the Ministry of Mines appears to be overstate the actual value of the metallurgical grade bauxite as compared to the price discovered by the OMC based on transparent method of electronic auction. The discovered price through national e-auction conducted by OMC state PSU is less than rupees 1,000 per ton, whereas with the formula as prescribed through notification, the ASP works out to much higher than even the ex-mine price of bauxite. It is understood that the conversion factor of 6.4 as notified by the central government has been derived by backward calculation from the London Metallurgical Exchange price of aluminium, taking specific value and or percentage of cost of certain components in the set price, like quantity and cost of alumina and alumina bauxite. This methodology with such presumption may not indicate the exact conversion factor, which will be slight variation factor being in percentage, would lead to substantial change in the calculation of ASP. The average sale price is required by the state government to calculate the value of resources in monetary terms to decide on the net worth eligibility for participation of the prospective bidders in the auction for grant of mineral concession. Hence, such ASP need to be derived appropriately so as neither overestimate nor underestimate the value. The unreasonable high ASP may affect the rates of premium to be obtained by state government consequent to auction of bauxite for grant of mining lease. In view of the above, the representation dated 25/10/19 of OMC and 27/9/19 and 7/1/20 of Aluminium Association are forwarded herewith. A request to consider revising the methodology prescribed for deriving the average sale price of metallurgical grade bauxite in order to align it with the realistic pit mouth value of the material. Now, I'll just pause here for a minute. This rule, in any case, is not for sale of bauxite. This rule is for the purposes of sale of the mine block, mineral concession block. And your lordship, the other day I was doing that other case. In a mineral concession block, the price starts from 2% of the price. The minimum, the floor price is 2%. Then the first auction takes place. The highest in the first auction becomes the second auction starting price. So invariably, it is never 100%. So this rule was nothing to do with the sale of bauxite. This is what this state is also rightly understanding, that this rule has got nothing to do with sale of bauxite. This was the, and if you have a very unrealistic problem, I'll tell you the real problem was what? By valuing the plant depending on the capacity or on the basis of the reconnaissance or on the basis of the prospecting that had been done, you estimate a certain value. When you estimate a certain value, and if you want to ask for bidders to come, then the bidder has to give a percentage of that as to meet the bidding requirement. Now, if a very unreasonable price is taken like this, then bidder will not be able to participate because he will have to give the earnest money on the basis of the value which you fixed here. Problem really was this. Problem was not with regard to our bauxite, and that will be clear from the next document also. Please see lot thereafter. High Court of Delhi also said the same thing, that you determine the in accordance with law. That is the serial number 49. Now, Lord 2020, while the 19 policy had just been notified, they come up with the 2020 expression of interest inviting applications for long-term linkage with OMC state-based users period for purchase of bauxite. Period is 5 years. Here they say that method of fixing a floor price for the national e-auction has not been decided. So the state-based end-user industries interested to sign LTL with OMC for supply of bauxite should be given an irrevocable undertaking from a person duly authorized by the board of the LTL party on stamp paper that they shall make payment of the differential amount accruing out of revision of price with the retrospective along with the applicable interest on receipt of written demand from OMC without demur legal recourse. It was stated that MOU signed based on the end-user industries who have already signed LTL with OMC for bauxite may not apply again. In response to this notice, LTL signed buyer may apply for revision of quantity. Then, Lord, the central government reply to them is very important, Lord. That is at page 797. In fact, Your Lordship has skipped that. This is just a preliminary reply. Then please come to serial number 52. We submit an undertaking as they ask for. Now 53 is my first writ petition, because now for almost 1 year there has been no supply. And in this writ petition, I say to do the national e-auction with the same price as per your policy, which is cost of production plus 50% profit. And this was all during the COVID time. 54 Lord, your Lordship allowed the petitioner to lift 1.9 lakh 5 metric ton upon furnishing and undertaking. Then lockdown was imposed. Then Lord 56, one-time measure. '58 Lord is the letter from the OMC, from the government of Orissa to the OMC. This is very, very important. Just see this plot. This is in the writ petition at annexure 30, page Lord 457. This is from the government of Orissa to OMC.
There was already an order passed by the High Court, and then it says that you continue supply in terms of the order of the High Court. And so far as the national e-auction is concerned, we'll have to calculate the average price in terms of that notification.
That's right. That's right. To avoid contempt. Now, Lord, please see after 58. In the 58 bottom, Lord, if your Lordship will just see, there are 5 auctions were conducted on the basis of this Rule 45, and just see the floor price 1707, 2011, 2430, 2752, 2959, and no bidders. No bidders. All unsuccessful. Then Lord 59. We file our second writ petition. When these 5 auctions were failed completely, there was no bidding, and obviously no supplies were coming to us, so we filed the second writ petition. In the second writ petition at serial number 62, they filed their counter affidavit saying that we will only go by the floor price as determined by Rule 45.
This very interesting counter affidavit was filed. That's why I'm asking in that. We have referred 62 and 63. What they say that once they say that they have conducted these auctions strictly in terms of the mandate given in the letter issued by the government of India, the fines. But secondly, additional affidavit that the sale contract on record at the price of 1775.
1717 is the price determined on the basis of Rule 45. So they say we will do the auction at 1707. No bidder is coming. Still, they say we will go as per that only. That is why your Lordship then gave the price of 1000 as an interim price, and that is continuing for all this while. 8th October. At serial number 65, Lord, is the interim order by this court. Your Lordships are then compelled to pass an interim order. Order is passed saying that 1000 rupees will be the price, whereas the last successful auction only at 673. So your Lordship have erred on the side of revenue by saying that all right, as an interim we'll say 1000 rupees, which is continuing till now. That is the interim order which is continuing till now.
They did not challenge the interim order.
No. They know that they can't. So that is why they are. But they keep taking us undertaking from us that if we don't succeed, whatever price they will determine, we will have to pay. That is why, Lord, ultimately we had to come with this amendment and this. Then, Lord, again, 9th of March 21, fifth national e-auction again failed, no price discovery. Then 69, Lord, is my third writ petition, again challenging this new auction, 45 new regime, which here we challenge the application of Rule 45. They say Rule 45 is wrongly being interpreted. Here, Rule 45 is meant to be completely for a different purpose, which will come immediately now, Lord. Bharat Aluminium, being an auction purchaser for its plant located in Chhattisgarh, also moved this honorable court by filing a separate writ petition, impugning the fifth national e-auction, which was conducted pursuant to the OMC applying Rule 445 and also assailing the decision of OMC to applying Rule amended 45(1) on mercantile sale of bauxite. Then, Lord, is the 71 is our writ petition. 72 is again, Lord, this court disposed of the writ petition, saying that has withdrawn on the statement made. Where is the affidavit of the central government in the other writ? Please see 76, Lord. This is the understanding of the central government to the Balco writ petition, who is the author of Rule 45. Just see this. Where is the understanding of the central government? Which page is that? No, where do they explain this? Where is it? Yes. The understanding of the central government is reflected, Lord, at serial number 81, where the central government filed the second affidavit in the Balco writ petition. But let's come to the second one. Just see, Lord, at page 860, which is annexure 49, that is to the main writ petition. In the Balco writ petition. Where is the explanation? Which page is the explanation? At 877, if your lordship will come straight away. Yes. 877, lordship, paragraph 13. This is the affidavit of the central government in the Balco writ petition. Paragraph 13. That it is humbly submitted that Orissa Mining Corporation herein conducts auction of mercantile sale of bauxite, mineral, and not auction of mineral block as stated herein above. It is submitted that auction of mineral block for grant of mineral concession and national e-auction conducted by OMCL for sale bauxite, two distinct activities. In the case of bauxite through e-auction, it is for the merchant seller OMC to decide the floor price. And then say, if you lordship will see the next para, ASP forms an integral part of the grant of mineral concession, including realization of royalty. Right. Your lordships are reading from the first affidavit. Yes, there also it is there, but this one clarifies more, my lord. In fact, paragraph 14 and 15
Yes.
in the second affidavit, it will be, my lord, page 878.
Yes, yes.
So they explain that this mineral auction rule 45 is for the mineral block sale. Not
They also say that it is open to people
to decide the price.
decide a floor price.
That's right. So that clarity is given by the central government that look here, you can go ahead and decide the floor price, whatever you want. Sale of mineral, the mercantile sale of mineral is not covered by this rule at all. This rule is only meant for the sale of, and that too, Lord, this whole thing started with actually a representation by the state of Chhattisgarh, which said that because of this rule, we are not able to get any bidders because the price at which, Lord, where is that? This should be there. Because the price at which we are asking them to give the valuation of the mine is so astronomical that the bidder is not coming forward. Just should be that letter. Which is that? 872, Lord, in the same document. Just have a look at 872, Lord. The necessity for amending Rule 45(1) of the Mineral Concession Rule and introduction of conversion factor originates from a proposal that was received from the state government of Chhattisgarh in December 16 to issue necessary directions to IBM to publishing ASP of metallurgical grade bauxite for Chhattisgarh as 2 bauxite blocks had been identified for the auction. The then existing formula for ASP of metallurgical grade bauxite given in 45(1) had an error as the conversion factor for reverse calculating price of ore from metal was missing. This was realized while the state government Chhattisgarh was processing an auction for mineral block having metallurgical grade bauxite. When calculations were done by IBM using the above formula, ASP worked out to 23,860 per ton for bauxite with 42.5% alumina, which was much more than the prevailing rate of the said grade. Hence, there was a necessity to have a separate formula of ASP for metallurgical grade bauxite for auctioning of mineral blocks. So this whole scheme of 45 has nothing to do with lot of this merchant sale of bauxite. This is only with regard to mineral block when the block is put up for sale. Now, Lord, if your lordship will come back to the list or date. At 83, the 7th auction also failed. They insisted on because yes. Then they floated the 7th national e-auction. Again, there was no price discovery. Then we filed an IA seeking extension of the order of 7421 for total agreed quantity of bauxite in accordance with terms and conditions. Petitioner, your lordship may skip all that. Serial number 90. Now they amend the long-term linkage policy, and here they bring in the floor price. Just see plot at page 36 of the list of date. In the policy itself, notwithstanding the application by the central government, the policy itself says floor price for national e-auction may be fixed as per Rule 45 of the FCR as amended from time to time as per notification issued by the state government. So they brought in this in the policy in spite of the central government clarifying that this is nothing to do with merchant sale of bauxite. Then, Lord, again, 8th e-auction, nothing happened. Then we filed another IA. Then, Lord, 94-hour writ petition was disposed of, permitting us to make a comprehensive representation. We made a detailed representation on 96. In this representation, we said that the author of Rule 45 has clarified that this has got nothing to do with merchant sale. Why are you repeatedly insisting on this as the floor price and not getting a single buyer? And if your lordship will see in this letter only at page page 37 in the middle, H. H. This unfair change forces Vedanta, despite 100% value addition, to pay twice the price of bauxite compared to its contemporary. Hindalco is paying 432, Nalco is paying 487. They are all Orissa-based industries, aluminium, and we were paying 1,000. So we were paying double of what they were paying, who are our competitors in the aluminium industry. Then we also again make this request of cost of production plus 50% profit, which is what was in the 2018 policy. Then we make a second serial number 98, we make a second representation. $100 representation is disposed of, again reiterating the same, that Rule 45 will be used. Then Lot 101, we file a IE for restoration of our writ petition. Then 103, your lordships give us the liberty to file a fresh writ petition. And 104 is the present writ petition. 27/3/2023. After this also, Lord, 105 is the 9th e-auction. Then 107 is your lordship's interim order. Same 1,000 rupees per metric ton. $109, Lord, they send another draft LTL agreement for further period of 5 years to the petitioner. Then 113, Lord, is our letter to the OMC pointing out the draft LTL which was not in alignment with the judicial orders. And there, Lord, if your lordship will see in the same list of date itself, the third bullet point, the supply of bauxite has been completely curtailed with effect from 1/4/23. Please note that due to lack of domestic bauxite, alumina refineries on the verge of shutdown, Vedanta cannot afford any further stoppage of supply, and the plant survival is at risk while we issue this letter. So we were literally begging to them to somehow keep my supplies at that rate. Now, Lord, very interesting, 115. Just see this document, Lord. 115 is a demand of 2,000 crores made by them. That your lordship will find at page 148. So your lordship says 1,000 rupees, and your lordship said that I give an undertaking that whatever price will be discovered, no price discovery is happening. So they say that whatever is the reserve price is our price. 1,000 you pay, difference you have to pay, and they calculate 2,000 crore. This is the demand letter. I just want to show that. But that then your lordship clarify that you can't, that demand is never implemented against us. But they are, so if your lordship will recall, last year, huge mention was made on their behalf that we have to recover, because this 2,000 becomes now 4,500 crore. We have to recover 4,500 crore. Such a big industry is not paying us this money, and then your lordship put it as item number 1. When I go for the amendment to the writ petition and I say that this is a case of promissory estoppel, we should go back, then they start running away. They don't want the hearing to happen. So then they realize that they really don't have an answer to promissory estoppel. So then this urgency of 4,500 crore suddenly blood fades into oblivion. So just see I'm just wanting to show the basis. The basis is the price which they claim to be the floor price as the basis. And 1,000 I paid, differential is 2,000 crore. This is how the demand is now.
Yes.
तो वहां से दिखा दीजिए अगला वाला था 4,500 crore. Then Lord, your Lordship will just see this agreement 117. Again, to 2023, we have to sign an agreement with them where we say that we'll pay 1,000, but difference whatever will be charged ultimately after the rate is decided. Then, Lord, in the first e-auction, where a small quantity went at 3,000 rupees, is when I realized that I'm in a trap now. They put some say 1 million ton. Somebody said took 1,000 tons of some very small quantity of that at that floor price. If now by writ, because I was all the time saying that it should be, because floor price was only the floor price. Ultimately, the price had to be discovered in auction. So in one of these later auctions, some small quantities were picked up by somebody. So then I realized that if I don't go back to my promissory estoppel, they will, because my undertaking is already there. And then they will say the whole thing has to be paid to me at this, whatever discovered price that has come in these auctions, which is the first auction, just price, which is that, just give me that. 1st January 2024. Serial number 126, 1st January 2025. This also doesn't go through because the buyer doesn't come forward to submit any document, but a price is discovered, 2,967. My friend is right, Lord. Just see 121 also, serial number 121. In the 2023 LTL, just one second. In the 2023 LTL policy, which is superseding the 2022 LTL policy, which had 45.1 as the floor price. Now the policy takes away the floor price. There is no floor price now in the policy. Although they are existing, although they are still insisting that 45.1 will apply, but the policy doesn't say so. So only for a period of 1 year, from 22 to 23, the policy said 45 rule will apply. Now it doesn't say so. But still they do the same auction on the basis of 45 rule. And then, Lord, in 126, there is a bidder at 2,967 for a small quantity, but the sale doesn't go through. And in the 16th auction, again, there is a small quantity being bought by Hindalco and Pioneer for 3,009. That your losses will get at serial number 127, bottom. Yeah. Then, Lord, 128 is their IA for vacation of interim order and directing petitioner to pay the amount mentioned in OMC's letter of 30/10/24, that is 3,398 crore, on the ground of the success of the 13th auction in favor of Pioneer. These are also for small quantities, where the total quantity being coming up for auction is in 1 or 2 million tons. 1 million ton. The person who's wanting to buy is some 1/4 of a million, 2.5 lakhs at 2,967. Now, where is this chart जो उन्होंने डाला इसमें 3,000 crore वाला? यहाँ से दिखा या अगले से दिखा दे? इसकी कॉपी आपके पास है क्या? इसकी कॉपी दे दो. So if your lordship want to have a bird's eye view, all the auctions I have put it together. First auction, if your lordship will see, 4th April 18, floor price 462, sale price 465. Second auction, floor price 548, sale price 553. Third successful auction with that lot cost of production plus 50% profit is 673. Price successful is 673. Then lot right from fourth auction to 12th, there is no price derived. And the floor price is as per rule 45. 13th e-auction, there is lot a party who quotes 2967, but no price discovery and no quantity dispatch. She doesn't pay anything. 14th again lot unsuccessful, no bid. 15th again no bid. 16th, as against the price of 3009, there are two bidders. 17th against as against 3128, there is one bidder for a small quantity. 2 lakh tons unallocated. 18th lot, there is again a bidder for a small quantity. 1 lakh tons unallocated. 19th, no weighted average price derived. 20th again lot 2820, again for the whole of the quantity. 21st, no weighted average price derived. 22nd, again there is a buyer, Pioneer 3037. And then 23rd onwards, there is no price discovery in spite of lot the auction at the rule 45. This is going right up to 29th of April 2026, which is as early as a couple of days, 4-5 days back. So this is the status of all the auctions done by them. Now, my respectful submission is that if my prayer in the unamended writ petition had to be, supposing, allowed, then they would say there is a price discovery. There is an auction price, so you have to pay me that price. So the period when I agreed to go for the floor price and the price discovery was a time when I realized that we are very close to my offered price or the original price given in the first agreement of 2004. But if it is going something like 10 times or 15 times above that, there is no question of my remaining. So that's the time when, and fortunately for me, my correspondences throughout, even till now, have always been that you have to give me 150 million ton at the price determined, promised. That has never changed. So when Motilam Padampat, one of the argument taken is, and I should read that part straight away, that there was an acquiescence or there was a waiver. The Supreme Court says that waiver has to be properly pleaded. And in this case, fortunately, there is no pleading, number one. They don't say there is waiver. In the reply, they don't say that there is waiver. In the reply, they say agreement is cancelled. Please appreciate the distinction. In the reply, they say agreement stands terminated. They don't say waiver. If they had said waiver, the Supreme Court covers that aspect also. Here, there also, what they had wanted had not come, and something else had come which they had agreed to do while they went into the writ court. If they had said waiver, I would have then shown my correspondence and said that this is all under compulsion. It's an unequal bargaining power. I don't have a choice. I'm not getting anything for 11 years. I start getting something near to that price. I have no choice but to acquiesce, because I've been running from pillar to post, from chief minister to chief secretary to everybody in the state, and with no relief. So I've been running like this. So what do I do? So when your lordships permit me to amend the writ petition, it is at that stage, Lord, they realize that now the matter is going completely out of hand, because they don't have an answer to that except for the termination. If they had said waiver, I would have answered that. But fortunately, they have not said waiver, so I didn't have to answer that. Now, the demand notice of the latest demand notice.
That is a 3398.
No, the latest is 4,400. Serial number 134, my lord. And the document your lordships will find is in their reply at 197. They can't make a demand because there is an interim order, but for information, they are saying this is the demand, to show to the court that there is a huge demand as far as we are concerned. Just see, Lord, this document at page 198, the table at 198. they have taken the auction price, floor price as per Rule 40 of their reply, Lord, of their reply to the amended writ petition. Counter affidavit to the amended writ petition, page 198. So even for the successful auctions, they are even asking differential even for the, just see the first demand, Lord. Where 673 is the successful auction, where there was no bidder, the highest bid was 673. There also they 1707. And the difference is 1034. Then 1707, 673, 1034. I'm so sorry, Lord. Page 198 of the counter affidavit. It will be in the form of a table. I'm so sorry, Lord.
Yes.
You also have the table. Now, please see the first demand. Bid floor price 1707. Floor price charge 673. This is the auction price which they get. And they say no difference, you'll have to pay 103. Second 1707. Auction price 673. They say you have to pay 103 for difference. Then third is Lord 1707 and your lordships with 1000, so they say 707. And then 2011 and then 1000 and 1011. And that is how Lord this whole demand right up to October 24 comes to, even for unsuccessful auctions, they have gone by whatever is the floor price as per Rule 45. And they say that this is all calculated internally by them. So this amount, if your lordship will see at the right hand side, comes to 4,455 crore. So, Lord, this is how fanciful is their demand on the basis of, Lord, whatever they feel is the basis for them to calculate. And they are making this claim against us and saying that this is the kind of revenue which is admissible to the state. Which number is this? Now, Lord, I'll just like to show some judgments, Lord. I think the rest is only just a narrative of what happened thereafter. So, really speaking, nothing turns on this. Various affidavits filed, etc. And they say that this document has wrongly been placed, etc., which is those couple of dates that went in that as well. And the documents I've already showed to your lordships are those documents which, if they had filed in the first reply, I could have placed it in the rejoinder. Since they didn't place it in the first reply, I placed now in the rejoinder because they placed it for the first time in the second counter affidavit that they filed. Now, Lord, if your lordship will just kindly have Justice Chandrachu's judgment is, of course, it's a very interesting judgment. Justice Chandrachu's judgment is not dealing with an promise to an individual, unlike in ours. That is dealing with a policy that you have fulfilled the policy and the state doesn't give it to you from the date on which it was promised. They give it to you prospectively. High Court decides in favor of the industry and Justice Chandrachud also confirms it. But ours is a much better case than that. Here there is a direct one-to-one discussion where you ask me to invest in the state. You say these are the facilities I'll give you, and one of the most important facility is the availability of bauxite, 150 million ton, and because of which, barring China, this is the largest plant in the world today. China, of course, nobody can compete because they are not in a different league altogether as far as manufacturing is concerned. I believe they've set up a car manufacturing facility, BYD, which is as big as San Francisco city itself. That's the kind of factory they are able to set up. So apart from China, I am the largest in the world today as far as the aluminum smelter lot is concerned. So just have a look at the, because this is the only argument which can go against me is not with regard to waiver. Just see Motilal Padampat Udyog.
Concern is that if there is a prevarication of this stand at the different stages, maybe because of some compulsions or because of the smooth running of these measures or your plant should not suffer. What will be the impact thereof?
That is covered in Motilal Padampat. I want to show them.
In,
Your lordship absolutely have put the point at the right point, right nerve absolutely. Please see Motilal Padampat Udyog. Just give this Motilal. Actually, the Indian jurisprudence on promissory estoppel is different. Your lordship knows that from the English one. There you can use it as a defense. Here they have first time enlarged it to be used as a sword or as a cause of action. Now, please see this question of waiver, if your lordship will come straight away. At paragraph 5. Actually, identical facts. Just see paragraph 5. We shall first deal with the question of waiver, since that can be disposed of in a few words. The High Court held that even if there was an assurance given by the respondent number 4 on behalf of the state government, and such assurance was binding on the state government on the principle of promissory estoppel, the appellant had waived its right under it by accepting the concessional rate of sales tax set out in the letter of 5th respondent number 5 dated 20th January 1970. Exactly same, Lord. I was promised something, I accepted something less. That's the waiver. We do not think this view taken by the High Court can be sustained. In the first place, it is elementary that waiver is a question of fact and it must be properly pleaded and proved. No plea of waiver can be allowed to be raised unless it is pleaded, and the factual foundation for it is laid in the pleadings. Here it was common ground that plea of waiver was not taken by the state government in the affidavit filed on its behalf in reply to the writ petition, nor was it indicated even vaguely in such affidavit. It was raised for the first time at the hearing of the writ petition. This was clearly impermissible without an amendment to the affidavit in reply to the supplementary affidavit raising such plea. If waiver were the properly pleaded in the affidavit in reply, the appellant would have had an opportunity of placing on record facts showing why and in what circumstances the appellant came to address the letter dated 25th June 1970 and establishing that on these facts there was no waiver by the appellant of its rights to exemption under the assurance given by the respondent number 4. But in the absence of such pleading in the affidavit in reply, this opportunity was denied to the appellant. It was therefore not right for the High Court to have allowed the plea of waiver to be raised against the appellant, and that plea should have been rejected. So this is the only thing which, according to me, can go against. This is neither pleaded by them, and if it had pleaded, I would have shown that under what circumstances.
I think the principles of right to defend in impartial manner, if I say so. Because if you plead something, then at least the other side would be in a position to know that what you wanted to plead. And then he will be getting an opportunity either to explain the reasons for issuance of any letter which is construed as a waiver on your part, or he may repudiate that particular portion that there cannot be a waiver from that conduct. But if you just raise the point, which is essentially a question of fact, It's not a, though it has an element of law, but essentially it is a question of fact which is also set there. So that question cannot be decided in isolation thereof.
That's right. So just to complete this part only, my lord. Here in
According
this,
to you, they have not pleaded anywhere that you have made your right.
firstly,
That supersedes that particular agreement which was entered into.
no, their only plea is that this agreement got terminated. The only answer given by them in the reply is that that agreement was terminated. So you don't have any right.
It was not terminated in toto.
It was only
partial termination. So
to the extent of JVC. That's right. That's right. So if the answer is only that, now supposing if they had gone further and said that notwithstanding the agreement, they after signing this LTL agreement or this agreement with us or this long-term supply agreement, they have given up their right. Then Motilal Padampat would come to my rescue and I would have said that no, I should be given an opportunity to explain why did I do it? Whether I had good justification, whether not that Brajonath Ganguly will apply in this central inland will apply or not. Whether I can say that I didn't have the choice to bargain with you after having suffered for 11 years. I am taking the best possible that I am getting. I can't. So for 11 years, if I didn't get it, what could I have done? I had to wait till they came up with the policy ultimately, and they were always alive to my requirement. It is not as if not that they were rejecting my case at any point of time. Till today, there is no letter from their side saying that your original promise is not there at all. It is only in this pleading for the first time when they say this agreement was. So when I this agreement of 2004 was relied upon by me in the writ petition. That is why your lordship permitted amendment. Otherwise, amendment could not have been allowed. In reply to the writ petition, they could have then only in the first counter affidavit said that no, this agreement is not to be relied upon because this is already terminated. They chose not to do that. When I asked for an amendment and the lordship said that this is already pleaded, so what is being asked for amendment is only a prayer on the basis of what is pleaded. They bring up this termination issue for the first time. When they bring up the termination issue, I show that look here, your old gazette notification after the termination accepted that I have to be given the supply in terms of the promise. So, and your even your letter, Lord, later on to the just see that 15th letter, just make it accept the 100% supplies to come to me, which is there. Just show that letter. One letter, Lord, I just need to show. In the gazette notification. ये पूरा आया है? I have not read this. This one second. इसमें कहाँ हो? Yes, Lord. Just see the gazette notification once again, Lord, which happened after the termination. Probably I didn't emphasize on this. Rejoinder, page 167. Fill the notes. Now, Lord, what I have done for your Lordship's consideration, just to simplify it, all the judgments on promissory estoppel, I put them in a tabular form. So the first one is Bombay High Court. The government of Bombay passed a resolution in 1865 granting municipal corporation a lease of certain land at a nominal rent for 99 years renewable in perpetuity. Acting on the promise, the corporation took possession of the land and spent considerable sum of money building shops and stables. Decades later, in 1897, the Secretary of State attempted to eject the corporation on charge significantly higher rent and charge significantly, arguing that original lease was not formally executed and the seal as required by the statute. The court applied the doctrine of equity. Although the formal statutory formalities for contract were not met, the government had created an expectation through its conduct and resolution inducing the corporation. The government was stopped from evicting the corporation. This established an early equitable. So this was then the equitable doctrine. Promissory estoppel Lord came, of course. Then Lord, this is Lord Denning, the second judgment, which was Lord that rental.
47.
Then Robertson Lord is 1949. Then Indo-Afghan is the first judgment of Supreme Court.
Is an equitable estoppel. It is a various kind of an estoppel that is compared.
So estoppel is equity. So what they say, Lord, these are equitable considerations originally. That equitable consideration now has been given the legal name of promissory estoppel after Lord Motilal Padmapat. Justice Bhagwati's judgment, which your Lordship will find the sixth judgment in this. But in Justice Bhagwati's judgment, I found this portion of Lord waiver. That was important, so I read that part only. But otherwise, Lord, every judgment I have realized what was the issue and how it was decided. And I have one more, Lord.
There are, if I correctly remember, there has some kind of a, the diverging view that is really coming.
I would say two aberrations in very extreme rare.
Some says promissory estoppel, not that inchoate right or inviolable the principle that it has to be done in every cases. In some cases, they recognize the concept of a promissory estoppel and then apply it as a sword, as you said. Sometimes sword, sometimes as a shield.
Now, so in India, unlike in India now it can be used as a sword. England it still can't be. It's a defense only. Here they have this principle
concept. It is called an adverse position.
like adverse position. Previously, it used your lordship right. Now it can be used even in a suit. You can ask for a declaration of title.
Principles under the Transfer of Property Act, Section 53A, part performance.
53.
Possession, you can
Possessory right. Or 6 of these specific as a shield.
But not now as a sword.
No, now it has been even that has been held as no.
Now as of
anyway, that is not.
As a sword.
One judgment they have held even now, as far as even adversary position, adverse
position, Bangla Sahib's judgment of the Supreme Court that says only shield, not sword.
No, now it has been.
That has been reversed.
Yes, that's what I'm saying. They say now it can be used as a.
Always. If you look at the editorial comment in Bangla Sahib at the pocket, you will find a very fine distinction since 1960s judgment.
That's right, good. So I brought in all the judgment, Lord. Right, there are about the last one is the Justice Chandrachud judgment, Lord, which is that that is the second last. Last is, and one case is of Orissa also. Supreme Court judgment of Justice Lahoti, which is serial number 13. Industrial policy years 80 and 83 attracted investment. State government contractually agreed to supply raw material at a fixed rate. Justice serial number 13, Lord. The respondent was persuaded to set up industry based on the industrial policy. The state on 27/4/89 proposed to revise the royalty rates drastically upward from a back date. However, on 1/3 so it was decided not to alter terms which have already been acted upon. The court held that to attract the so mere written agreement is not enough. There must be a representation. However, the unilateral decision was arbitrary. Solemn promise, even in absence of written contract, is enough. The state was bound by the contractually agreed rate for the stipulated period. So, not one but several judgments. I'm probably the aberrations are in very, very different kind of cases where there is a statutory intervention and large public interest. I'll give those also, the two or three judgments where the court has taken a contra view. But those are in cases where, firstly, there has to be a statutory intervention. Statutory means a parliamentary intervention. And there is a large public interest involved. Here, there can't be any public interest. Here, not if you are wanting me to set up industries and the multiplier benefit that I'm giving to the state by virtue of this investment, that can't be not compared to a simpliciter sale of bauxite. Sale of bauxite, a merchant sale of bauxite to somebody who has an industry somewhere else can't be compared to a bauxite sale to an industry within the state which is generating so much of additional revenues and additional employment and additional. I have set up not only both these places I have captive power plant also. I am not even using the state power for the purposes of running these industries. All that is at huge investment. Now, Lord, this is a chart that I made just for your Lordship's consideration. Just have a look at this one. Stable will be if they go by their first notified policy, which is of 18, which will be cost of production plus 50% profit. First column is the as per my agreement of 2004, cost of production plus 50% royalty. So it would have been 449. I have paid them 535 on the basis of cost of production plus 50% profit. April 19 to 20, I have paid, it would have been 491, I paid them 6112. Then it would have been 625, I paid them 80, should have paid them 804 because hereafter your lordships have put 1000. So I paid them actually 1000. April 21 to March 22, it should have been as per my agreement of 2004, 663.
You made a comparison that whatever you are paying as per the interim order is much
higher.
what the contractual rate ought to have been.
That's right, which is the first column. The contractual rate is the first column. Second column is what I had agreed in between.
That's true.
That is the three quarters. So this second column is not cost of production plus 50%
According to you, this is a reciprocal promissory estoppel which has operated against you.
as far as the first three auctions are concerned.
Yes, second column.
Second column, yes. And third is, of course, your lordship's 1,000 rupees. So in any case, it is. And the small volumes that they have got that at that higher price, really speaking, is neither here nor there, because if in law I'm right, that will not make any difference. But even that is a very, very minuscule 1% of the total sale which the OMC is doing. So that can't be a basis to say what should be my price, especially when I have an agreement and there is a promise, and on the basis of that promise, I have not set up this investment. So that is all, Lord. I thought I'll keep it short so that Lord, the judgments also, instead of showing all the judgments, I only showed Motilal for the simple purpose that that waiver part. Because I also was being troubled with the waiver part. So I thought if there is a direct judgment on waiver, let me show to your lordships one way.
Yes.
May give you some date, any date after next week. I did not, next week I not be able to answer.
This day was fixed only so that we can finish the matter.
No, my friend is taken not the whole day, and I need some time. Can you any date
I
after
can do
next
it
week?
tomorrow, Lord, your lordship.
Tomorrow
I have already fixed some urgent matters which are there. I do not want to disturb that.
But after next week, any date, any date, my lord, I even on 11th, I am prepared to come. Kind of help on 11th. But next week, Lord, I have not certain engagements already been taken or I've already not taken time. I have nothing for on this High Court to tell my lord. Kind of help on 11th, we will finish on that. I'm not asking for it. 11th to 12th, whatever they choose, my lord.
What about Mr. Das, who will be arguing? You?
Advocate General will have.
But ensure that somebody argues.
Yes.
You would love to hear him, there is no doubt about it, but because other matters are getting delayed further.
Well, and when senior is paying for 11, paying for 12.
11th, he's asking. I think he will not take much time.
I will take some time, Lord. I have to treat all the ordinance.
That's a very ambiguous word.
My lord,
Could it be not 12 then? It's also 12th is also convenient to my friend. No, he said 11th or 12th. I'm only going by his date.
Your lordship is keeping the mining matter on.
Well,
My lord, 12.
12th. Let it be item 1, Lord, because otherwise
it is second half maybe better.
not first, fresh mind, fresh.
This is more convenient.
I will pray, Lord, let it be written in disposition, because otherwise, Lord, we have seen, Lord.
I have to hear.
Lord, I'll finish it. You can have it at 2 o'clock. I have it now.
What is the difficulty in the morning?
From morning, Lord, if there is some Lord, I have to not get ready and then so come.
If it was, if your lordship fixed it,
I have
let it be in the morning, Lord. Because I'll have to rejoin.
So that we can check off. In the morning, it will come.
Then we can, then I can do a small rejoinder also if necessary, otherwise, no. So same retain its position, Lord, in the list. And interim orders to continue. Lord, retain
Can
its
you do
position.
one thing?
Yes, Lord.
Whatever you have argued, I understand the case number or something which is referred to documents. And you put it in a bullet form.
What I was
It
saying.
should not exceed 2 pages.
Very good. I'll do that. I'll do that.
The moment I said, you give me a
No, Lord, I'll do that. I was only suggesting, if your Lordship feel it appropriate, can I make a compilation of the documents that I'm relying upon so that they all come at one place? Only for compilation.
No, I just wanted a bullet point.
I'll do that.
You have referred this.
So I'll come next time.
And within the bracket, you have to just indicate
The page number.
disclosure in the rejoinder.
I'll do that.
I just wanted to know that this is what a disclosure for the first time in a rejoinder, so that if he raises the point, I will be able to identify that
I'll
the
do-
documents really wanted an exemption or expunction, actually.
But if my friend cannot give it, whatever he prepares,
No, you have seen the rejoinder. This is all he has argued is for because you are taking time. By this time, many other matters will
I
be
know,
here.
I know.
Sometimes